Yes, we have directed that you activate 12(1)(EE), and we said that let the central government through his PSU take a decision to run. Yes. Yes.
Obliged, my lord. Obliged.
Item number 2.
What is this matter? This is yes, execution. You were saying
Yes,
about it.
My lord, without going to the actual matrix of the case, I think the last order of the Honorable Supreme Court, my lord, 3/4/2025.
Yes.
There are trial argument. Better.
What it says.
My lord, the land of the appellants to the extent of 1 acre 37 decimals in plot number 353 in Mauja, Noyapalli, North, now Jodha Bihar, was directed to state for implementation of the town planning scheme to Noyapalli North 2. Alleging that no compensation was paid to them, the appellants filed a writ petition before the High Court of Orissa seeking a direction to retransfer and reconvey the land bearing plot number 352, 353, and 344. The High Court filed an order dated 21/5/2009, allowed the writ petition to the extent that the state of Orissa was directed to allot equivalent land in exchange having similar potential value within 3 months. The said judgment attained finality as SLP number 32998/2009, moved by the state, was dismissed by this court on 9/1/2013. Since the state did not comply with the above stated direction, contempt were filed before this court, in which Justice R.K. Patra, a former Chief Justice of the Sikkim High Court, was appointed on 11/3/2014 to determine the market value of the land in question. Justice Patra, in his capacity as an arbitrator or a neutral umpire, determined the market value of the appellant's land to be at rupees 14 crores per acre. It appears from the record that the appellants filed execution proceedings before the High Court or as determined by Justice Patra. In those proceedings, the High Court has passed the impugned order, holding that the most fair and proper method of determining the market value of the appellant's land would be as per the Orissa Stamp Amendment Rules 2001. The High Court accordingly accepted the market value as rupees 7 crores per acre. The state was consequently directed to deposit the balance amount going by the rate of rupees 7 crores per acre with the registry of the High Court, while the appellants being non-payment of the full amount as was assessed by Justice Patra are before us. The state agreed by the redetermination of the market value of the land by the single judge of the High Court, has gone in an intra-court appeal bearing execution first appeal number 1/2017 before the High Court, which is still pending consideration. We have heard Lawrence Senior Counsel for the appellants and Lawrence Advocate General for the state. In our considered opinion, and as the facts noticed above to speak for themselves, the issue and just market value of the land is pending consideration before the revision bench of the High Court in the above mentioned proceeding. While the appellants will be at liberty to contend that the High Court in execution cannot go behind the determination of price by Justice Patra, the state shall be equally entitled to contend that the report order determination by Justice Patra suffers from some legal flaw. Such like issues being sub judice before the revision bench, it is not expedient or desirable for us to express any opinion at this stage. To protect the interest of the appellants by directing the state of Orissa to deposit the balance amount as per the rate determined by Justice Patra with the registry of the High Court, during the pendency of the first appeal. The said amount, along with any additional amount value or deposited, shall be kept by the High Court in the form of fixed deposit receipts of a nationalized bank, fetching the maximum rate of interest. The appellant shall be at liberty to move an application before the High Court in the pending intra-court appeal for the release of some part of the amount in their favor immediately, subject to such terms and conditions as may be imposed by the High Court. We also request the High Court to backward expeditious hearing of the intra-court appeal execution first of expansion. My Lord, in further
What remains? What remains?
Apex Court, my Lord, has directed for release of some amount. 3 lakhs.
That is a different.
Yes.
We are not concerned. We are concerned with the merit of the appeal. We are not concerned that what part of the deposits have to be given to them,
Yes.
what conditions may be imposed to them.
Yes, ma'am.
We are concerned on the merit. There was already I would say, the arbitrator that was appointed by the Honorable Supreme Court to determine the market price. The arbitrator has determined the market price, saying that this is the rate per acre or per whatever.
14. Yes, sir.
Yes. So now we are at the execution stage. We know our limitations,
Yes, madam.
how far we can interfere with the original decree, how far we can interfere is the issue. You have to.
But I would like to submit my lord. Your Lordship, we go through the report and finish the report and scrutinize the report submitted by the Lord and arbitrator. How far the report is sustainable in eye of law. Only the Honorable.
Can we go?
Well,
Can we go into this aspect? Because the Supreme Court has also in very clear terms says that you will not interfere, but definitely the court may determine whether the market price which has been determined, whether it is appropriate, proper, or incommensurate with the other factors.
if
That's
the
the
report
only
is
scope.
correct, madam. If
That's the
report
only
is not
scope.
correct,
We can't say the report will be discarded. No. Supreme Court has also not said so. You just read.
the law. The law is, my lord, the executing court can interpret the decree when the same is not clear.
Sir, provided there is an ambiguity attached to it. Under what provision? One is 47.
Yes,
47 is restricted to executability, discharge, and satisfaction of a decree. You can definitely raise an issue regarding executability of a decree in case if there is any ambiguity.
Yes.
But can we go if the report is very clear?
report is not clear.
What clear? It has arrived at a particular decision that the market price of the land is a 14 crore per acre. Now,
My lord, the learned arbitrator has not taken research or taken any steps for calling for the report from the district valuation committee.
why?
As per law. That is the law.
Sir,
That
in
is the
case
law.
of a land acquisition, let us
No.
go by a very civil concept.
My lord, that is not.
If it
My
is a
lord,
land
the
acquisition
Lord
case,
arbitrator has
then how
himself
the
gone
market
to the
price is
expert.
determined? On the basis of an exemplars, on the basis of certain deeds which have been in a close proximity, definitely depending upon several factors. If it is in relation to a tract of land, and if it is in relation to a small piece of land, we know that how the adjustment has to be done.
He has gone to the spot and found that such building is registered, and he has reported, my lord, without taking the help of the experts.
What is the meaning of the word experts? You are talking about, you say that it should be done according to the stamp, Odisha Stamp
Yes,
Act.
stamp 2001.
Now tell me,
I'm reading, my lord.
I know the market value or a market price is the purpose of determining or ascertaining the the percentage of the stamp duty to be put on a particular document, does it has any impact on the actual market value under the acquisition proceeding? I'm talking in the sense of a special bench judgment of the Calcutta High Court. That's why I just referred.
I am reading the 2001 amendment, my lord. Orissa stamp use.
So the first question which I am putting it to you, whether the reference to a Odisha stamp rules or the act be made in ascertaining the market value. I will be very happy, I tell you very frankly.
Pardon, my lord.
I will be very happy if a circle rate is a benchmark for the purpose of ascertaining the market value. Welcome. In all
Benchmark value can be assessed from the competent authority, my lord. My lord, not not an arbitrator by going himself to the spot and assess the valuation.
there are certain materials which the arbitrator took into account
I will read, my lord, the
in arriving at this. Your only contention is that it should be done on the basis of the stamp.
Yes.
Now tell me whether it has any impact or it can be taken as sacrosanct in all respect. Sure.
The Honorable Supreme Court has not accepted.
No, it did not say so. Sir, what are you talking about? The Honorable Apex Court says that you deposit the money, what has been determined by the arbitrator in the court. Liberty was given to them to pray for a withdrawal of a part thereof. So the Apex Court never interferes. Simply says, since you have raised an issue, this issue has not been in that sense, though remitting the matter to the High Court to decide. But it does not really impinge upon or says anything about the market price determined by the arbitrator. And the arbitrator was appointed by the Honorable Supreme Court.
Maybe, my lord, the report is not very not conclusive, my lord. That was the report of the my lord, just appendix 2, rule 41, principles of determination of market. Your lordship can see the last page, my lord. Page 6. Page 6, my lord. In rule 41, principles for determination of market value. As a past part of provision, step below, for consideration once the particular property is classified according to the benchmark value can be assigned with relatively greater assurance, while the characterization difference preferred below cannot be called exhaustive of the various facts of the property. It must be noted that necessary to be selective in choosing few characteristics out of many for the system to be practicable. In the case of land, the following may be considered: classification of the land as a dry, wet, and the likely. Classification of ISM in the settlement register. Value of adjacent lands in the vicinity. the number of crops and
Still, my basic question remains.
guideline value. The section 37. Constitution of district level committee and subdivision council level valuation committee. The district and sub-district valuation committee shall be constituted with the following members, namely, the district valuation committee shall consist of collector, chairman, additional district magistrate revenue member, district sub-registrar member, convener, tahsildar member, and executive engineer, roads and building member, nominee of municipality corporation member, nominee of development authority, town planning member, two public persons nominated by the chairman.
Yes.
My lord, in delivering the judgment, the Honorable Apex Court has specifically stated that my lord, while the appellants will be at liberty to contend that the High Court in execution cannot go behind the determination of price by Justice Patra, the state will be equally entitled to contend that the report order determined Justice Patra suffers from some legal flaws. Such like issues being sub judice before the divisional bench, it is not expedient or desirable for us to express an opinion on this.
What?
Therefore, we would challenge, my lord. We challenge.
From what? To what extent?
Just I am sorry.
That
My lord, this is the flaw. This is the legal flaw.
the market price is
He has not.
is not concerning in the legal principles or the legal provisions. You are taking shelter under a particular legal provision.
Yes.
I am asking you whether it can be applied in such a case.
It's fine. Why
It
not?
has to be uniformly applied in all the cases of a land acquisition.
It is to be applied. How the welfare valuation will be assessed, my lord.
That is what I'm saying.
That is the DLC.
If the surplus rate is
District level committee is the competent.
sacrosanct, if the surplus rate is sacrosanct for the purpose of market price, let it be. I think the public at large.
Apart from that, my lord, the property was 1 acre 837 decimals, but report was in respect of 600 something.
1600.
1 acre. Your lordship can see the report. I am just I beg to how is dealt with the matter. Yes. Page 18. I know. That is the report by the learned arbitrator. Paragraph 11, just I am reading. What is the market value prevailing as on date 9/1/2013 of plot number 353 Kisam Sarada 2 area 6 acre 76 decimals. He has taken into account the entire area, my lord. But the disputed land is 1 acre 837 decimals. We are concerned about 1 acre 836 decimals that is surrounded by natural,
Accept.
my lord.
I accept. Then according to the legal principles,
Yes.
if the market price of a large tract of land is ascertained at certain price,
Yes.
then the smaller land cannot be less than the same. It must be higher than.
My lord,
So
that
we are
nature of the
increasing
land,
it. We are
that is
increasing
agreement.
it from.
That is a fallow land, my lord. Our specific plea is that is a fallow land that is covered with a drain, natural source, my lord, or drain and a road. That is not a residential area, my lord. That is our case from the very beginning. The learned arbitrator has reported regarding area 6 acre 676 decimals, which existed there are so many buildings. In Bhubaneswar town, my lord, it is the Bhubaneswar multi-story building there. My lord, in the reply dated 17/9/2013, filed by Mr. B.K. Patnaik, former Chief Secretary, to the Government of Odisha in the content petition civil number 20213, pending in the Honorable Supreme Court, it was stated that a piece of land covered by boundary 1, measuring 1 acre, appertaining to revenue plot number 1803, identified in Mauja Jayadevia, was considered. However, on verification, it was found that the said land was earmarked for parking purpose relating to drawing number BS 136, and as such, it could not be allotted to the applications. Another vacant space in revenue plot number 688 by 2556 was found to be encroached by Golas and other individuals.
These are all the past incidences. You have.
Just I am coming to the finding.
You have
Just
the prelude to the report that the factum or a factual aspect are simply enumerated therein. Nothing to do on an adjudicatory or a determining part. Because the genesis of this litigation is that their land was acquired for a larger public purpose. Initially, there were orders passed by the courts saying that you have to find out an identical land having the same potential values. You just give it to them in an alternative way. You agreed, you just went there, they identified, earmarked many land. Those lands were not found to be suitable nor having an equal value or a potential value. Some properties were already encumbered, being occupied by the encroachers, the squatters. You can't give it to them. Some properties were not having the same amenities, the facilities, the geographical advantages and the disadvantages. So ultimately, it was decided that no, we can't give you an alternative land. We can give you a price in lieu thereof. Now, once you took a stand that you will give a price, then the apex court appointed an arbitrator. You go and determine what should be the market value. Now the arbitrator has determined the price, saying that this should be the value which is in commensurate with the property which they have acquired. Now you are saying that I am not agreeing to that particular market price. The apex court, by reviewing the matter, has observed that we are not going to say anything on that. Only thing is whether the price or a market price which the arbitrator has determined, you have a right to raise an objection to it. The unlimited scope of this particular appeal. We can't transgress the barriers which has already been put by the Supreme Court. And even if on a general principles, you know, the limitations which every executing court in here, on a very limited ground, the court can.
And if there is ambiguity in the decree, that it can be.
Sir, there is no question of any reopening
the law.
of decree, sir. This is not a question of. I'm just beseeching you to please introspect. If you read the order of this apex court, it does not talk about any adjudication on the decree. simply says that since this innovative device has been adopted, you have a right to raise the question on the price which the arbitrator found it to be a market price. Nothing beyond that. What ambiguity in the decree? The decree that you'll have to give them an alternative land. Is the decree?
Yes. I was ready to give the alternative. He did
You have
accept.
not been able to.
The state-
You
state-
suggested even
Suggested, my lord.
before the apex court, that was
So many
discarded.
letters were issued to him.
Sir,
So many letters.
this was discarded. Then why the apex court appointed an arbitrator to ascertain the market price? That means there was no concept of an alternative land to be provided. Can you turn around and then say no? That the entire exercise done by the apex court will be futile. Absolutely.
No.
Futile.
No.
Because
That is not correct.
the report has to be thrown.
That is not correct, my lord.
Report has to be thrown. Then again,
But we are challenging the report, my lord.
original
We are
decree,
challenging the report.
and then say I am giving you alternative
Bad in law.
land.
My lord, we are challenging the report. We are not.
So can you fall back and say that no, the decree is for alternative land? We are ready to provide an alternative land. Can you go? This is diluted by virtue of this order.
But it was offered. The land was offered.
What it was
Offered. So he did not accept.
So you must have said the apex court that it is offered. These are more having same potentials, having the same facilities, amenities. The apex court did not agree. Can we go beyond the order of the apex court? No. Yeah.
Absolutely.
So you have to squeeze your argument in a very compact shell.
We have an argument, my lord, only will object to the report of the learned act.
Using the term object means a meaningful object.
Object. The entire report, your lordship, I will be allowed to read, my lord. How the report is submitted, my lord. May I be permitted to read?
You have read the report, sir.
Yes, report.
You
Paragraph
read the
11, I am
report.
having
You
the
read the report.
In the reply dated 17/9/2013 filed by B.K. Patnaik, former Chief Secretary to the Government of Odisha, in the contempt petition civil number 2202 of 13, pending in the Honorable Supreme Court, it was stated that a piece of land covered by boundary wall measuring 1 acre appertaining to revenue plot number 1803, identified in Mauja Jaydev Vihar, was considered. However, on verification, it was found that the said land was earmarked for parking purpose relating to drawing number BS 136, and as such, it could not be allotted to the appendix.
That is your statement could not be allotted. So, your proposal for giving them or allotting that land, you say earmark for parking purpose for BS, so we can't. That's your secretary.
Yes.
So,
Just I am just.
oh,
Another vacant space in revenue plot number 688/2556 was found to be encroached by Kosara and other individuals, and as such, it was not found suitable. An area measuring 2 acres 695 pertaining to plot number 148 under Khata number 1033 in Mauja Sahibnagar was available. However, on verification, it was found that the said land was being used by Sahibnagar Durga Puja Committee for performance of Durga Puja and other festivals. The applicant Sri Biranchi Narayan Das, in his evidence, stated that the benchmark valuation of the 3 plots is 12 crores per acre, and the potential value of his plot number 353 may come around from 25 crores to 30 crores per acre. Exhibit 5 series are the information made available under the RTI Act received on 29/6/2013 in respect of benchmark valuation of the plot in Mauja Jaidabiyar, in which plot number 353 is reflected, and Sahidnagar, rupees 10 crores per acre residential, 10 crores per acre residential, and 12 crores per acre commercial have been indicated valuation. Exhibit 6 is the information received from the district sub-register Khordha on 25/3/2014 in respect of valuation of plot number 353 Kisan Sarado in Mauja Jadabiyar. It is mentioned as 10 acre per acre, 10 crores per acre. The applicant Sri Virantinana Das in his evidence stated that he did not accept the area allotted to him in Mauja Sampur because it is an underdeveloped area lacking in road communication, and its value would be 1/10 of his land. The witness stated that the area allotted to him at Sampur would be at a distance of about 15 kilometers plot number 353 at Jadabiyar. The sub-register Khandagiri had Exhibit 7 in letter dated 17/7/2013 replied to one Sri Samcharan Pathi under the RTA Act that the benchmark valuation of agriculture residence and commercial kisan of Sampur Mauja respectively is 1 crore per acre, 1.20 crore per acre, and 1.40 crore per acre. The benchmark valuation at Sampur being very low, the applicants have rightly refused to accept the area allotted to them at Sampur. Exhibit 12 is the order dated 1/6/91 of the Bhubaneswar Development Authority giving permission for construction of residential buildings on plot number 353 in Mauja Jaidabiyar. Exhibit 13 is the order dated 2/9/96 of the Bhubaneswar Development Authority giving permission to the applicant for construction of steel plus 5-story residential apartment on plot number 352 and 553 in Mauja Jaidabiyar. Exhibit 14 is the order of additional Tahsildar Bhubaneswar permitting conversion of 578 decimals of land out of plot number 353 in Mauja Jaidabiyar from Sarada 2 to Ghoravari Kisan. The above clearly shows that although plot number 353 has been shown as Sarada Kisan of land, construction of resident building, multi-story building is possible, and that is why the Bhubaneswar Development Authority has given permission to the applicants for necessary construction. On the basis of the application, the Tahsildar has corrected the revenue records from Sarada 2 to Ghoravari Kisan. The Learned Counsel appearing for the GA Department referred to the report of the Deputy Accountant General, Odisha, dated 6/12/2013 in support of his submission that the rate of land claimed by the applicants at 10 acres per acre is not justified. The opinion rendered by the Deputy Accountant General is not acceptable for the reason stated above. During my spot inspection, I noticed that on the scheduled plot number 3, during my spot inspection, I noticed that on the scheduled plot number 353 and near and around it, a lot of residential houses, multi-storied apartments, shops, and other commercial establishments have come up and are in existence. Sri S.K. Rai Sadar, in the counter affidavit, Exhibit 21, filed by him in the Honorable Court, at first paragraph 33, has admitted as follows. After getting facilities like road and drainage channel arising out of the scheme, a multi-story building, namely Vishnupriya apartment, has been erected and belonging to petitioner, which is adjacent to the land gifted by the petitioner. The valuation of the land have also gone up owing to the road and drainage facilities created due to implementation of the town planning scheme. Witness number 3 examined on behalf of the appellants is one of Saroj Podar, a real estate developer. He has asked that he has been in the business of real estate in Bhubaneswar since last 25 years. As per his evidence, he had constructed the Bhubaneswar Development Office building, Kalinga Stadium at Bhubaneswar on behalf of ITCO, government and private buildings. At present, he is doing a market building of Bhubaneswar Municipal Corporation. He stated that he constructed a building on 1 acre of land of plot number 353 and Jaydev Bihar, he would offer 24 crores per 24 crores per acre to the landowner. His offer for payment of compensation to the landowner may be exaggerated one. The benchmark valuation made by the government is an indicator of the market value of the land. Rule 40 of the Orissa stamp rules lays down that the market value guidelines prepared under chapter shall be issued as soon as they are prepared and shall thereafter be revised biennially from 1st April. This means the benchmark valuation is liable to be increased further. The petition dated 22/3/2014 of the GA Department praying to determine the valuation of the scheduled land, my lord, having classification of Sarada with reference to valuation of Sarada land available in the neighboring Moja Bharatpur is rejected in view of the what has been stated above. Keeping all the aspects in view, by giving a reasonable concession, I assess and determine the market value of scheduled plot number 353 measuring 6 acre 677 decimal as on 9/1/2013 at rupees 14 crores per acre and not less than 15 crores. How? DBC is not there, man. District Valuation Committee is a proper.
10 crore, 24 crore.
How he has assessed 14 crores?
Difference.
How he assessed 14 crores? And because he has gone to the spot.
Have you come across with the judgment of the apex court which says in a land acquisition cases some guesswork is policy? Are you aware? I think he has taken a very reasonable conservative view.
But he has submitted report, my lord, in respect of 6 acres 766.
Sir,
My Sutland is 1 acre 87. Limited, man. Yes, surrounding area he has some reported.
Sir,
That is
you
correct.
have read the arbitrator said that the land Basically, developed multi-stored buildings, the markets, the roads, everything has come up.
Yes, but not in the
And
Sutland.
you are offering a land which is a 15-kilometer away. Even your officer has come that it says that 1 crore. Then, apropos the entire value, you have to give them a land, not 1 acre which you have taken. You have to give more. If it is 20. Incommensurate with the one
My lord, my respectful submission, he
that you are not given.
accept
Until
you
you
are
are that yes, let there be a value. I can't give you alternative plot.
DBC,
That is why
DBC
the court, the
District Valuation Committee has submitted the report.
What
It was nothing.
What,
But straight to approach, my lord.
nothing. Some examples were taken into account from the sub-registrar's office. What more one can do?
My lord, I am confined to the argument regarding the report as per the Honorable Apex Court report submitted by the learned advocate.
The apex court has said that the valuation,
Yes, sir.
you can raise the issue on that.
The valuation is not, that is disputed,
That
that
is
is
what I was saying.
valuation is not arbitrary, that is arbitrary, my lord. Completely
Anything more?
arbitrary. There is no basis.
Yes.
Giving rupees 14 crores per acre, that is no basis. How he ascertained? How he came to know the 14 crores? Therefore, I claim that it is to be not to be accepted, the report of the learned advocate.
That's all. Thank you.
Enough, I can reply if my done.
Would you reply?
Madam,
I will just
thereafter,
clarify the doubt regarding 6 acres, 676 piecemeal. Your Lordship may see the order of the Honorable Supreme Court passed in by the Supreme Court in content petition number 202 of 2013 in page 2. Heard Mr. V. Shekhar, Learned Student Counsel, appearing on behalf of the petitioner, as well as Mr. Patwalia, Learned Senior Counsel, appearing on behalf of the respondents. After hearing and with the consent of the both parties, we pass this order in order to assert Karkalu prevailing as on date of the property, that is plot number 353, area 6 acres 670. That is the order. That is to be not confined to 1 acre 836. It was up to 191/2013. What was the rate of this
So
area?
this is order appointing an arbitrator on consent of the parties.
With the consent of the parties.
Did you find an application for modification, clarification, or review?
My lord, just
This order, as it was passed, did you apply for a clarification, modification, or review? You are more putting an emphasis on the area, 6 acres.
yes.
But if the order applicator says that what market price he will determine and on what, on the what, what means area of the
Area.
land.
Area.
If the area of the land is indicated in the order to be 6 point something,
Yes, ma'am.
can an arbitrator go behind or beyond that? He has then correctly said, because that is the order.
And it was with the consent of both the parties.
It may be appointed. That is not disputed.
Oh,
How our small
And-
land will be valued?
Now understand. Yes, next.
Apart from this,
So he has not applied for any clarification, modification.
no, ma'am, nothing.
Yes.
He has just accepted and accordingly
Who accepted? Who accepted?
accepted
No, no, we have not accepted.
accepted the
have not
appointment of
accepted.
arbitrator.
Yes. Fine.
My lord, government has not,
You
my
have-
lord friend
you have the
is
fullness
saying that
of-
we have accepted.
Sir, you have.
No, what you have accepted? Accepted the appointment of the
I think
arbitrator.
it was a time, it is time to take a breath, rest. Let him complete. We will call you again.
My lord, your lordship is aware of the facts and detail previously it
My
was.
brother is asking something.
You have read.
I'm little bit hard of hearing.
Are you referring to order dated 11/3/2014?
Yes, my lord.
No. No, just now you have referred to
11/3/2014. My lord.
11/3.
Yes, my lord. That is the order passed in contemplation 202 of 2013.
With the consent of the
I'll
party,
see.
in order to ascertain the market value prevailing, that is 6.6.
That is what I said.
Correct.
Yes, sir.
You will know that since it's the petitioner's land for the purpose of drain and embankment road, they did not give any compensation for which but the petitioner filed one writ petition before the Honorable High Court to tell the compensation. On 21/5/2009, Honorable High Court directed to give them the land in exchange, having similar potential value with a period of 3 months. They disputed that, they did not give, and they went for the appeal before Honorable Supreme Court. On 9/1/2013, Honorable Supreme Court accepted the report of this order of Honorable High Court and modified to some extent that
Instead
In
of
case-
giving a land, you give a
in
price.
case no suitable land is available, state is permitted to pay the market value as on date. As on date with 9/1/2013. That was the order. They did not go for the review of that order. Nothing, no further action. Then, since they did not give any land in time, as per the direction of Honorable Court, we filed one contract petition. During that period, they allotted one land which is having 1/10 value of the land of the petitioner.
That is, yes.
For which,
The
since it
arbitrator has
disputed,
recorded.
my lord, since they disputed the value of the property, we prayed before the Honorable Court and the court so moto told that let us fix one, appoint one arbitrator to determine the value of the land. Your lordship know the discretion and the power of the Honorable Court under Article 142 of the Constitution, they can for the settlement of the dues. They can appoint arbitrator, they can do anything to complete justice, they can do it. And accordingly, they appointed the arbitrator with the consent of both the parties, who took the overall evidence, documentary evidence, witnesses from both the sides, and thereafter giving reasonable concession, determined the value that 14 crore per acre of the land, as on date 9/1/2013. They filed an objection before the Honorable Court in that content petition on 20th/11/2017. And that objection was heard by the Supreme Court in the content petition, and then they did not set aside the order of the this report of the arbitrator. All these things, whatever they are saying now, they had raised all that question in that. So when the content petition dropped, it was dropped that we don't hold any. It is not possible to hold that the petitioner, Chief Secretary of the Odisha government, is not has not deliberately or willfully violated any court's order. Therefore, despite the court's observation, we give the liberty to the petitioner to go for the execution of the order passed in their favor. So, what is the question arranged? What is the order to be executed? Lordship that the first day asked what is the order to be executed. My lord, when the order, the report of this arbitrator is not set aside, no explicitly no such direction has given. So it is implied that the report of the arbitrator has merged with this direction for execution of the order. So that report, that valuation is to be executed in this arbitration case. My lord, when this proceeding was going in content petition, he had already read this report that the Chief Secretary had stated in their affidavit that he wants to give the property at Sahidnagar, at Zoydevia, at 4 crores, whose benchmark value was 12 crores per acre. Benchmark values, not the market value. And the petitioner, who's my client, he told that my property value will be 25 to 30 crores. If some nowadays, if it is constructed, that this builder is constructing, he is giving 50 to 60% of this market value. Now the builder is this appellant of keep it secret. This owner of this land is a landlord of Bhubaneswar. He is now constructing, several builders are now constructing this. They are giving him this everywhere in Bhubaneswar that is going on. So therefore, one builder who came to him that if that land is given to me, then I will give 24 crores acre. Arbitrator did not accept it, told that it is rejected. And taking into all these concessions and everything, then the arbitrator told that the value of the property is 12 crores, which is 2 crores more than that benchmark valuation as per their suggestion, but they were intended to keep. Now the question arises, can they go beyond this this direction of the Supreme Court, where the matter has already attained the finality? Article 141 of the Constitution, what does it say? Everybody is binding on the order of the apex court.
Law declared.
Yes. Then this is the state government is what they are doing to their to suit their the circumstance. They are doing what they're saying, whatever they are saying, they are writing whatever they are doing. They cannot provide this or the stand that whatever they will say, the burden is with them. They will say that we are doing this, doing that. Or the burden will be that we are not doing that. This is not permissible under this under Article 141. That is the state is a welfare state. They should see that how their citizens are well protected. So the question now arises whenever they did not this amount of the execution was started. The execution in the execution proceeding, appellant had filed an execution before the register judicial. They objected that in his CMP, they filed that the register's order is not sustainable because he is authorized. Under Article Order Rule 45, under Order 45 Rule 15, the order of the Supreme Court is to be enforced. So, not by the register of the High Court. Again, then in CMP court directed that this will be heard by the single judge. Then single judge passed an order 7 crores per acre without taking into consideration of the arbitrator's report, without giving any reasonable reason that it is 7 crores per acre. When the arbitrator has taken all these aspects, everything, documents, everything, and they are what they are saying, Nala was there, all these things, that was all considered in that year. That no Nala, nothing was there, because in the record of right, there was no such mentioning of Nala in that record of right. during that by the record of right is prepared by their own officers, settlement officer, their own officer. It is by petition itself. So, taking into consideration everything, he had prepared the report, 14 crores per acre. Now they are reporting when they did not pay that amount and the single judge made the value that 7 crore per acre. They themselves, that 7 crore per acre, that was on the submission of the state council, not by the honorable judge itself. They told that we are ready to pay 7 crores per acre, as the per acre, as per the benchmark valuation. State is ready to.
No, that is not correct. That is not correct. That's not-
Yes, yes, you see the order, 11/8/2017 of Honorable Single Judge Sutter.
No.
You see, read it. Then we challenge that in SLP number 362 of 2017. We challenge it before the Honorable Court that the Honorable Single Judge has not taken into consideration of this report of this arbitrator, and the report, the valuation determined by him, it's not correct. So on 3/4/2025, that matter was converted to civil appeal, and it was whatever was the directed or Rakshit knows that it was court directed that the in execution value determined the arbitrator, the executive court cannot go behind that, and gave the liberty that we should do content that the executive court cannot go behind this value determined by the arbitrator, and they were permitted to do so if any legal process is there. Simultaneously, they were also directed to deposit all the amount that was directed, determined by the arbitrator, and they have deposited also. And whatever was there to release part of the amount, your also has released accordingly. My question is that whenever all these things are, and the Supreme Court has time and again directed that this arbitrators, as per the arbitrator's report, this amount is deposited. Arbitrator, the executive court cannot go behind the report this that is determined by arbitrator. So it is a merger with the original order. So how can when the order has been attend the finality, can it go behind that? Behind that, nothing. No, they cannot go. So the arbitrator's valuation is binding. It is a reasonable report with all concessions. The report has been and there. They should they are binding by the order of the Supreme Court and the Honorable Executive Court in appeal also. They should confirm that. This is my
Thank you.
My Lord, in replies or reply. This is the consistent plea of the state government that the acre of the that area is 40 lakhs. Inadvertently, the law officer who was conducting the case inadvertently stated. But that is the specific plea, and we supported by affidavit and submitted that the 40 lakhs, maximum 50 lakhs. And my Lord, there is no scope for filing any review application or recall or modification before the apex court. Immediately, the order was passed, and that is to be adjudicated before my lords. And another thing, my Lord, your Lordship, kindly consider, what's the gift deed executed? How it can be reconveyed and retransferred by the writ court? It is the competent court. Civil court is the competent court to decide whether registered document is executed, my Lord. Jurisdiction lies with the civil court.
Much water has already.
Okay, I'm sorry. But that has happened.
Bring back.
That would have been dismissed.
On a civil law concept, I appreciate it, but still, much water has already flown.
Well, we stop. But the writ application was not maintainable initially. That could have been
Talk
dismissed.
about the civil law, the concession means on fact by the lawyer. What are the recourses open to a client when a concession is made by a lawyer? On fact. I'm not talking on law.
Yes, ma'am.
I know. Concession on law is no concession. But fact, what is the recourse open to the client of that lawyer who made a concession? I'm talking in a civil sense as you appears in a civil matters. I'm talking.
Ma'am.
What is expected to do? Nothing has. Any application. We'll decide.
But I look.
Yes. For orders. Yes. In the next. Yes, withdrawal.
Item 3.
I'm sorry. My lords, what had
Application
happened?
has been filed for withdrawal.
My lords, we are withdrawing this petition. There was some confusion between the previous advocates and the company members. So this application was filed. We will not press this application. Your lordships may take it up some other thing.
They wanted to withdraw. There is an
They go the application.
Books, because I made a very concrete rejoinder. Rejoinder.
On that penumbra theory.
Specifically, one is issue-wise, in note of rejoinder dealing with issue-wise, the Attorney General and the Advocate General's argument. So that is one note, not sure I have it kept on the side. And the opening note which I
This
asked.
is volume 1.
This is volume 1, which is the opening note when I argued the matter in the beginning.
Then
And the new one, the
new
one
one.
with the blue flag has been given.
In that very volume.
Okay.
So both have been noticed, put that in that cover.
Okay.
So I will be dealing only with the second note, but just one or two parts of the first note will be this. In addition to this cover, brothers, your lordship may tell the court master to keep the 2 small volumes of case law extracts. These are extracts. The main judgments are also given, but the extracts will facilitate. They are in 2 volumes, continuation. Whenever some cases where I'll be showing the relevant quotations in the relevant parts. The way I wish to proceed, subject to my lord's kind discretion. Is basically, first kindly see the index of the rejoinder note. That is the first note on top, the blue note, the blue flag note.
Yes, index.
Yes. So this is my summary of the broad contentions, tolerance, and then the response is given in the text. The first was, I don't think very seriously pressed a very important point, but anyway, I've dealt with it. His argument that estoppel applies against me from challenging Rule 12A because it has been incorporated in the MDPA. Something which I submit with great respect has to be only stated to be rejected in terms of the law. I'll deal with it. The second is, that the challenge to Rule 12A, we have tried to make it very narrow. And his sub-points there are, it's a very narrow focused challenge bias, which is wrong because 1, the MMDR is a legislation in public interest, and your lordship must teleologically apply 39B, etc. Then what my Lord the Chief Justice just said a minute ago, the expression sustained production occurring in 4B carries within it the penumbra of mining activities. Now this word penumbra is nothing but an adjective to suggest that production in the English language must include dispatch. Another word of the English language, penumbra, will not change the ordinary language meaning of the English words which in normal English doesn't include dispatch. Production and dispatch are two words. But my learned friends with this flourish use the word penumbra, to subsume by overbreadth two distinct concepts, conceptually distinct, factually distinct, legally distinct, saying that it's covered by the penumbra, as well as shadows and the footprints will be so wide as to change the language meaning of two different words. Then third facet of this submission is that 12A 1A authorizes imposition of a penalty for shortfall and there cannot be something which is not specifically provided on a deeming fiction. On top of that, first to provide a deeming fiction or a notional compulsory dispatch, and on top of a deeming fiction, you provide penalty. The validity of Rule 12A has to be seen from a combined reading of these three. We will do that combined reading and see whether it still remains ultra vires or not. My submission is completely ultra vires. And the demand notices levy the imposts of premium for meat, failing to meet notional dispute. Then, they say that 12A2 in response to B, they say it's not vague or arbitrary. And the Attorney General has in his written submissions given that interpretation, which I have dealt with in CI. And my contention that they have done a completely, facially, patently invalid classification between brownfield and greenfield is the issue which the Attorney General has defended in C2. An extremely important, most important in the index is that, and it's a very nice way of brushing aside the vital document and the vital concept in the mining law. They say mining plan is only a technical document, does not override the provisions of MDPA. Though one is contractual, one is statutory. Though one is fundamental to expert bodies, it is brushed aside as a technical document. I'll be dealing with that. That's 16 to 22 page numbers, which is very, very important. Then tender document requires the petitioner to seek for a mining plan having the same approved production level, that of the ex-lessee for the entire duration. We say that at the most requires 2 years. Year 3 to 49 can't apply. They say no. That's the last one. Now, I will speak faithfully to this note only. But just for one thing, your Lordship may see the summary of my submissions in the opening note, the top note, the first page of it. Just to rewind for less than 3 minutes. The broad head which I had argued in the opening are listed conveniently at page 1 of my original note. And then I'll turn straight away.
Yes.
The first page of the first note. These were the heads, they're only the heads, just to remind your Lordships, the contours and the boundaries of the submissions. In a nutshell, the case of the petitioner on unconstitutionality of 12A is based on each of the following, each of which is specifically without prejudice. First, the issue of notional compulsory dispatch is brought out by A capital bracket 1 capital A, whereas all the sections containing the source of the power limit themselves to actual removal dispatch. That is, whereas the actual powers are in 9, in 9B, in 9C. That's the section. 12A is the rule. Consequently, in providing for a stipulation of compulsory removal dispatch, the same is ultra vires. This is the first head. My second head was, when I opened, 12A2, providing for compulsory dispatch for the 3rd to 50th year. For most cases, first year over in any case. 3rd to 50th year is ex facie contrary to 4B and 8B of the MDRL, which limits themselves, but the only source is 4B and 8B, and they limit themselves clearly to 2 years. As a matter of fact, when I come to the section, when I deal with it, it will be conceptually unimaginable, I say. And I may be guilty of exaggeration, I hope I'm not, but I still use the word unimaginable. That these provisions of compulsory dispatch made as a transitional safeguard to avoid scarcity in a crossover period. Assuming they were specifically provided as they were for first 2 years, could by implication be applied from year 3 to Y3 to Y49 or Y50. Because it is unimaginable that one is the previous person's production limits, because you have to go by the previous years for the basis for calculating the last 2 years there become my first 2 years calculation. It is that person's basis will control and govern me from his grave till 50 years. One is 50 years, as Lord Keynes said, in the long run we are all dead. We are probably dead before the long run. 50 years is not the long run, this is the ultra long run. The whole world changes in 10 years. Steel may not be metal at all. If you can provide compulsory dispatch notions for 50 years for iron ore, you'll have those technological changes, factory change, everything. So the very concept, which is why the central government bodies have objected to it. But I'm going ahead of my own story. Then let us see. 12A as a whole is also ultra vires 5 and 18, since the latter gives primacy and mandatory efficacy to the mining plan, which in turn specifies and planned manner of mineral production each year, which in turn is in complete contradiction to the compulsory dispatch regime purportedly created by 12 capital A. So mining plan was clearly is negated, forget undermining. Additionally, for the same reasons, 12A also contradicts 13.1 and 11.1, which remain operative and unchanged, and also gives similar primacy to the mining. So mining plan is the third set of submissions I'd make. Separately, A2 is also ultra vires and unconstitutional since it is vague, devoid of details, inoperable. Now, this is linked to number B. D is linked to B because in addition, there are no guidelines, which is what the written complaint of the central government is. We don't know how to operate 3 to 50 years. How do we calculate? Not me writing, they are writing to themselves internally. The entire regime of compulsory dispatch is also patently unreasonable. This is the Article 14, which I have elaborated at some length. And last is actually E and F are both is arbitrariness passive, and F is the invalid classification, brownfield and greenfield. Whereas the moment the mine becomes operational, which is by a rule on the giving of a certain document, brownfield and greenfield distinction vanishes. The argument made is the mine becomes operational after 8 years. Factually wrong. 2 to 3 years. I'll show the provisions, I'm coming to that. Now, if the mine becomes operational after, let's say, 3 years, that's the highest 3 years, then the moment that point occurs, then the greenfield and brownfield become indistinguishable. But here, second part of your penal action starts from year 3 to year 350. In a period when brownfield and greenfield are indistinguishable, applying only to brownfields. From 3 to 50, there is nothing like this with the greenfield fellow. So we both start the race together. Maybe on the third year we converge. Let us assume against me. I'm assuming against me. I'm not accepting it. When we converge, we are the same here at year 3. Thereafter, for 50 years, I am hit by this. This other fellow has nothing. Nothing at all. Come back to my current problem. One other caveat before I come, I'm sorry. That is that your lordship is rightly and advisedly dealing with these 6 issues. I read them, my A to F. These are, if I may use the word, constitutional and or legal. And that's the correct way of the lordship. The lordship will hold against me, the lordship will hold for me. Either way on these issues. Now, in the unlikely event that I lose on all the issues, there are still factual issues that should not be decided. So that should be kept in mind, which we have not covered or argued. There are issues in the individual case. For example, my case, give only example, would have there's a batch of cases here. Well, my own case would have a case where they did not hear me at all. There are other provisions which they violated. So that, your lordship, just keep in mind, we are carving it out. Should not be assumed that my writ deals fully with them, but your lordship has by sidewind decided something is not argued, because that's obviously your lordship's remit at the moment is the legal and the constitutional. That's just the caveat I'm putting in. Now let's kindly come to point, the 5 heads I've given for the rebuttal, for the rejoinder. I don't think I left out any of the respondents' arguments. I'll go one by one. So the first one was at page 1 of my blue flag, is the submission that I apparently am stopped from challenging itself Rule 12A, since it is part of the MDPA which I have signed. That's the short point. Now, this is on the face of it, greatest respect to my learned friends, otherwise also wrong, but on the face of it, factually wrong, is my first submission. Just see 4 dates I have given. This tender, which does not refer to dispatch and only to production, comes in January 2020 as per my first date. There is no dispatch. We are now saying that you signed your death warrant by signing the MDPA, therefore you can't challenge. In the tender to which I bid, there is no dispatch. Clause is given, everything is given. I participate in March of 2020. The capital A, without the dispatch requirement for any market, number 3, is born in March 2020 after I have participated. So my participation is over, my signing, whatever I wanted to play in, I have done. There is no 12A. 12A which comes is not a dispatch 12A. The MDPA is executed in July 2020. That is 5 months, 4 months after the participation. What we are aggrieved by comes a full year and a half or a year and a quarter later on 10th of June 21. A subsequent legislation, I am stopped because I signed the MDPA when there was no legislation. I signed the MDPA on 22/7/20. I may be right or wrong or interpret. How am I stopped? There is a stoppable. That is one. So on fact alone, this argument doesn't arise. I signed the MDPA in July 20, I participated in March 20, and your impugned or objectionable regime came in June 21. Then, Manas, come to A3. Apart from the argument is no, completely. There is no amount of signing. Suppose Manas 12A is unconstitutional. Just suppose for a minute. How can my signings stop my 226 challenge to it? It's on the face of it, Manas. I may not have challenged it. I can challenge, as a matter of fact, provisions which are worked and applied and suffered are challenged. Unless it is shown in some particular case there is leeches. We are not talking of leeches here. We are saying just because I signed an MDPA which had a dispatch requirement, therefore you can't challenge it. The test that your lordship is unconstitutional, my lordship is constitutional, it's fine. Either is. This fellow is too well known to know, but seconds to my first.
So Olga Teghi's judgment.
Olga is given by me, Malas.
Yes.
Don't go to that, go to Express newspapers. Both are there. Give them.
Volume
6 days first.
Volume 3A. It's
3A. 3A and 3B are the two extracts. It will take just 30 seconds. That's the one.
serial number 2.
Yes. In this was
This one.
Yes. Page
Just
3.
put it. Yes.
What is it called? 3A.
Yes.
It's called 3A. Yes. So 3A, page 3. The lordship can take it. We've given all the big judgments also. The big bunches there. But this is anytime lordship wants to go there. This is just for convenience. Page 3, serial number 2.
That is what I am groomed at the bar. read the judgment from the first sentence or a word to a last sentence.
No, well, ultimately, on those nuanced ones which are directly on point, not for these well-known propositions, the Lordship also gets the context only from the first two paragraphs. Without the context, all judgment follows useless.
That is what.
That's the difference between fellows the used to thumb those AR manuals and take out those cases versus the computer press of a button now. You get hundreds of judgments, but the nuance is not available.
Nowadays, what I've seen that many young they want to put a focus on the head notes, which cannot
No,
be
never.
a true reflection of the judgment. At times, it may not.
As my chamber, I know my habit brothers and they don't dare do that now. That's very dangerous sometimes. Now, this express.
Not purely as a matter of history, but it's only because of head notes. The Supreme Court started what's called an authorized version. The Supreme Court reports was established only for ensuring an authorized version of both and the head notes. And the head notes, those very distinguished editors, would take it to the learned judge who had delivered the judgment.
You are correct. So far as the ILR, which is the most
Okay.
authentic
Yes,
I got ILR.
where the head notes may be prepared by an editor, but it has to be placed before the judge who authored the judgment. And then once he read it, then it takes a character of some kind of a binding efficacies. So these are the only one, I think the ILR or SCR, these are the two reports where you can try on the head notes as well. But still,
But to get the nuance of the
unless you
case,
get it, there may be a different reasons of looking at a particular thing. So one may look in a particular manner, one may twist it in a different manner. It is all the acumen and the skill of the senior members or the members of the bar.
In fact, as an archivist, I can tell your lordships that the position of an editor and an assistant editor of the Supreme Court reports was considered so prestigious and so valuable. They occupied rooms alongside the Attorney General and the Solicitor General in those days.
both the ILR and SCR fell into disuse because of the time lag. But now the SCR has been made completely accredited, not so the ILR. The SCRs are now
But here I
contemporary.
find in this state, mostly the members of the bars are very much interested in subscribing the ILR. I think that's a very nice.
Yes, it should have
No, we have
In some
now
state it has discontinued.
continued.
in our portal, Odisha High Court site portal, we are uploading as EHCR,
Yes.
all reportable and online that can be downloaded each judgment, judge wise, topic wise, judgment date wise, everything.
But what the law of the Chief Justice means is that where there is a contentious issue of law, there without reading the first 2 or 3 paragraphs judgment, then the ratio para, you can't really apply it. For the general propositions, this we can use. But so page 3 para.
Sorry, there was also another convention, that before a judge, when it was signed, the court master would seek instructions whether it could be reported. So, unreported judgments, I can tell your lordships with confidence, till 1980 could not even be tendered. Even engrossed copies of an unreported judgment, would be rejected by the court.
There was one attempt by some of the publishers. They wanted to, I think, take out a journal with the not unreported judgments.
And there is
Continued for a very brief period of time. I think hardly 10 or 15 or 20, I think the copies. But later on, it was discontinued. I think if you remember, that's your time. UJ. It's unreported judgments.
UJs. So as page 3 para 2, after the first 7-8 lines,
Yes.
the express, which is the previous one is Olga telephone. I'm just reading it. In public law, middle of that, the most obvious limitation and doctrine was cannot be evoked so as to give an overriding power which does not in law possess. Other words, no estoppel can legitimate action which is ultra vires. Another limitation is that the principle of estoppel does not operate at the level of government policy. Estoppels have, however, been allowed to operate against public authority in minor matters of formality except. In the previous para, as well as the more detailed para, Olga tells, which is in page 1.
Yes.
Then, Manas, I come to the second submission. The challenge to Rule 12A, they say, to which I am rejoining, is based on of construction because it is in the public interest and based on 39B. That's the submission at page 2 of my note. Now, we have no quarrel with the fact that MMDR Act is enacted in public interest. No problem. That's too general a point, and we have no problem with that. But equally, Manas, the 2020 amendment with which we are concerned, my para B.2, was also enacted equally in public interest, in more immediate public interest, to bridge the transitional gap as a result of leases expiring from a certain date in March 2020. That is the whole purpose, there's no other purpose. It's very clear. The SOR says so. Now, both the learned AGs said that 12A was enacted to increase the revenue and therefore to subserve public interest. That is too simplistic. The idea was very clearly that you will provide lack of any constraint in the 2-3 years of transition. That was to avoid that one. See how the stand of the government as argued is falsified by themselves in para B.4. I quoted it. Para B.4 at page 2. Letter of 26th of September by IBM says this verse. The stipulation of Rule 12A2 of the concession rule was introduced as a condition to ensure that raw material supply post-expiry of leases in 2020 and the production figures over the last 5 years indicates the supply of iron ore is more realistic requirement. They are complaining. So the reverse of scarcity is going on. Then why do they complain? Is the next page. Why do they complain? The annual production of previous year's lessee, whether over the entire period of the lease or any specific period, has not been defined in 12A2, which is exactly the argument I am making, and which creates confusion in defining the future production beyond the period of initial 2 years. So in the first 2 years, you take 80% of the last fellow's outgoing last. But there is nothing to say from year 3 to year 49. How will you do it? Further exploiting, this is the government saying, IBM, that is one of the most prestigious and important statutory bodies. Further exploiting the mineral resources over the entire period of lease as stipulated in Rule 12A2 is not feasible if another stipulation of the same rule to maintain an annual production equal to or more than the production of previous lessees during the balance lease period is followed, as being exhausted well before that of the expiry of lease. Now, on the other hand, to exploit the entire resources as per the stipulation of 12A2, the production needs to be ramped up to unsustainable levels in few cases. This is contrary to optimal and sustainable mining and conservation of mineral along with protection of environment and intergenerational equity distribution as per Supreme. The Rule 12A also impinges upon the rights of a lessee provided under Rule 17, wherein a mining plan indicating the proposals of production can be modified at any point time in the light of business environment. Well, how is demand and supply presupposed by external force in a prescriptive manner, real for year 3 to 50? This is being written by the government as a general, real, genuine grassroots complaint by a body which is separate. It doesn't do any actual dealing. It does all expertise, evaluation, technical stuff. That is their writing. This whole document, you need not see because I have already shown it to you. But there is a paragraph here. Just see page 440 of the writ provision.
If given convenience, only these documents.
And we also have a convenience solution going to the writ. And yes, I'll just see that.
Page
Page.
one is.
Not that. The same document is at 440 of the writ. Within convenience, column. It may be better to see it on the writ only.
Oh, this is a convenience compilation.
Yes, of the document, only documents, not case law. Now, the actual document which your lordship I have quoted is page 1. The one I have just quoted is page 1. Hello, got it? Now, what I quote is at the bottom of page 3,
Yes.
the stipulation. But the top of page 3, on the point that there is a glut, there is a surplus, there is no scarcity, why are you having rule year 3 to year 49? That gives figures on the top. I'll not read it, but see the figures given of iron ore in the countries 206, 244, etc. in the year 18.
It says is an adequate one. It says is an adequate one.
It's adequate. It clearly shows the supply side of the mineral is adequate, as my lord puts it. It is also pertinent to mention that export duty has been levied on all ground very recently. So what is the rationale of having a seamless transition with no scarcity has been met? This has very great relevance to year 3 to 49 or 50. Now let's come back to my note B5. B5. In view of the IBM itself, 12A2 requires production to be ramped up to unsustainable levels is in violation. This is what IBM says in violation. Then, the aforesaid concerns by the expert body IBM clearly indicate that the set of public interest and common good under 39B are not subserved by 12A. The opposite is happening. It is my contention or my stand which actually subserves public interest, as they are then decision. Now, the other argument was A, it is public interest, the AG said, B, it is 39B. C, he said it's a policy. So, who has said your lordship is striking down constitutional amendments and your lordship can't strike down an illegal policy? Policy is the lowest form. You have constitutional amendment, the basic structure, then you have a statute, then you have delegate legislation, then you have policy. So, what is so sacrosanct about a policy? That's the argument I dealt with in B7. I'll not read the judgment. Satyanarayan makes it clear. Interference by a lordship's in policy matters happens every day. So long as I show that they are demonstrably arbitrary, capricious, etc., irrational, disproportionate, violative of Article 14, all that. There's nothing so special about so-called policy. Then, this penumbra argument, the second argument, that because they are now faced with an argument situation where the text says only production, no dispatch. So they invent, I submit they invent something called a penumbra argument. That although it is only production, it is not dispatch, but production includes dispatch in a penumbrical manner. Let's see that argument. Yes, deal with it. Page 3. Sorry, 4. Page 4. Ex facie, production and dispatch are different and distinct with different meanings. The definition of dispatch and production are found separately under 3AA and 3FA. I'll just show you in a minute. This is important.
That's the definition part that
So,
has been given.
A in the English language, B in the definition. Nobody will, unless your lordship creates a legal fiction saying for all purposes production shall include dispatch. Then how can you assume them to be interchangeable? Penumbra or no penumbra? Then when the statute defines, now the 3AA and 3FA define differently, then where the concept of penumbra? With great respect, how can penumbra argument arise at all? Distinctly, while dealing with the same subject matter, the same cannot to the same meaning. Where the statute intended to use both expressions together, they have done in 4 capital A. This is very important. I have to show this to you.
It's very fundamental.
Well,
There are two concepts of the canon of interpretation of the statutory provisions. If the particular expressions of the words have not been defined, then if it does not admit any ambiguity, then it's a plain generic meaning, the simple meaning that can be attributed to it. But once it has been defined, then wherever it appears in the said statute, an attempt should be made to give the same definition which has already been given.
And third, the same act, when it wants to club the two together, this is when it specifically uses production separate from dispatch. in the same act. And your lordship is not to give meaning to
That
it
is-
because there's a penumbra argument. Your lordship will give diminished meaning to it because there's a penumbrical effect. But that can't be able to create this. So this sentence is important. B9, second part. The parliament has consciously used only the expression production in 4B, while choosing to use production and dispatch in 4A. So one is the point my lord just noted was that the two are defined differently. They have to be meant differently. But having defined them differently for some sections and purposes, parliament thought that we will include both for this section, but by using different words, production and dispatch. That also did not do in 4B. 4B they use only production. 4A they use production and dispatch. Your lordship is not supposed to rewrite a statute like this just because somebody has a penumbrical interpretation. That's not possible. The position further becomes clear that virtue of the fact of the Mineral Laws Amendment Act of 21, March 21, the same amendment introduced 32AA dispatch and 32FA production, and further substituted the phrase mining operation in subsection 4 of 4A, which concerns itself with lapsing of a lease with production and dispatch. They substituted it by production and dispatch. So one of the distinction is made 4 times in the same statute. 4A, 4B, then the amendment, then 32AA, then 32FA. Who are we to argue all these interpretations at all? We don't even arise because the statute is clear. B11 is my sequitur. This makes the legislative intent clear that firstly, production and dispatch are distinct, and secondly, wherever the legislature intended to use dispatch in conjunction with production, it has done so. But most importantly, it used only production in 4B. Your lordship is concerned with 4B in this case. In 4A, in the very preceding section, it says production and dispatch. Well, we have done an exercise that I must cover my entrance to the exercise, which is in B12. Dispatch is conspicuously absent in so many provisions. Now your lordship will start using, Bennion is a pretty urgent textbook. It's the mildest way of putting it. Started this fashionable phrase, teleological interpretation, but though it's a very, very good and a very in-depth book, it's very difficult to read. It doesn't really help practitioners so much who want a certain amount of black and white. But no amount of Bennion, philosophical abstraction, teleological interpretation, penumbrical interpretation. Incidentally, because penumbrical interpretation nobody has used till now. This is the first case where it has been argued by the response. Can get over the fact that I have listed 8 clauses or sections in the next
Can't
paragraph.
it be used in that sense that's may not be in a very expressive manner that has been used? But if you look at the broader concept of the penumbra or a penumbrical
Then
concept,
nothing but teleological,
So,
purposive,
that's right.
purposive interpretation.
that is what Article 21, right to life,
So therefore,
and which addresses or imbibes or
Yes.
several facets
so
of the life.
no,
in that.
certainly. So first of all,
My lord, if I may say so, sorry. My lord, this concept is actually, it is in the context of something which is opaque. And when there is opacity, it is dormant. You can't see what is behind it. At that time, my lord, like you have an eclipse, you have a little, my lord, edging around the eclipse. That is called, my lord, penumbra. It's actually, my lord, a term which is used in sciences, and it's got a very limited meaning, which is, my lord, even the entire case law in America, my lord, we'll deal with it. We'll tell your lordships it's completely, now, my lord, it's gone, even
There
out
has
of
been
fashion
a-
there.
There has been
A shift.
constant debate between a Hart and a Fuller on a penumbra.
Yeah.
One says a positive concept, one says it can't be positive. So these are the both.
may I say, these kind of delicious questions of interpretation arise with the following points are important. We cannot start going into an area which doesn't arise. That is why give me 2 minutes. First rule, I'll be as specific as possible. Otherwise, it becomes very, very abstract. Where the words are very clear in their words, in the normal sense, your lordship will not embark even on the interpretation of a word which is otherwise clear. That's principle number 1.
Won't be fixed.
Number 2, production. I'm not yet come to law matters. Production and dispatch in any form of English language, absent from special, have very clear meanings. We all understand what is production and dispatch. The two are fundamentally, conceptually different is number 2. Point number 3. The statute makes it used differently by amendment in March 21 in AA and FA. Number 4. The same statute uses advisedly only production for several provisions. There is a question of going into a penumbra search and a we don't have to go to teleological one. It's purposive. Which is penumbra may not be, but purposive is very much part of the logic tool. But it's simply, don't even call it literal. It's a commonsensical interpretation of the word staring your lordship in the face. But point number 5, the provision exists as production alone in 4B. Point number 6, the legislature in the same act, same section, previous section chooses that we will cover both, but in 4B we will not cover. How can your lordship not be asked to give meaning to it? And last, this word dispatch is absent in such crucial clauses. 10.3 of the tender. Next. Schedule D. 4 clauses of the MDPA. By the way, which all my learned friends are swearing by on the MDPA. 4B missing. 13.2 AA missing. Now, if your lordship is to apply and interpret a statute, your lordship always gave the example of 21. 21 is constitutional interpretation. And constitutional interpretation can be by incremental advance.
True.
A particular right to life, because life has so many facets. Because life has so many facets, production can't have a facet of dispatch when the act itself is providing for it. That's the point. So this is, and this table is very useful. I could show lordship each provision, but it is no point. But a very clear point I'm making. This word dispatch is absent. In that, what was B12. And we're given the exact page of the section. Of course, most crucial directly as far as the statute is concerned is C and D. C is 4B and D is 13.2 AA.
Yes.
Then there is B13. Actually, the doctrine is at the highest purposive. There's no such thing as penumbra, but let's say purposive. The doctrine of penumbra or the doctrine of purposive interpretation can only be resorted to when the plain words of a statute are ambiguous or lead to no intelligible rules. The first and foremost principle of interpretation is the literal rule of interpretation. Applying the literal rule to 4B. 4B is the one without the word dispatch. 4A uses both, the previous section, which categorically provides for conditions to be stipulated for sustained production only. Being clear, must be given literal meaning. Because it is very well known, I'm now going to cite it because one case still deserves citing, is Premanand. Same volume your lordship picked up. Just turn to page 4. You will say common sense is the best tool, unless sometimes become uncommon nonsense. So you need to have common sense is the first thing to apply. When you see a word, you don't go in a search for some other meaning of that word, unless you're mystified by the word itself. Page 4. In our opinion, 27C of the rules is plain and clear. This word plain and clear is a literal rule. Plain and clear. Hence, the literal rule of interpretation will apply to it. No doubt, equity. Now, this is supposedly in the favor. In my case, according to me, equity is in my favor also. But here, just see what they say. No doubt, equity may be in favor of the respondents because they were selected earlier. But as observed earlier, if there is a conflict between law and equity, it is the law which must prevail. The law which is contained in 27C is clearly in favor of the applicant. We cannot accept the submission. The language of 27C is clear and we have to follow that language. Now, all these judgments are at one place, just for noting. Hiralal, just one line at page 5, in construing a statutory, the first and foremost rule is literally considered. Very clear, but I'm not reading it. Then next para, 9, Swedish, the other rules of interpretation, the mischief rule, the purposive rule, can only be resorted to when the plain words of a statute are ambiguous or lead to no intelligible results. Lordship will not apply a test that first I will confuse myself. I will assume that it gives no result, then I'll start searching. That's what they're telling your lordship to do. That first you imagine that there is no result possible. Why the result not possible? The word is very clear. Then Prakash Nath Khanna is the other case cited, etc. All of them is one place, so it's a useful case. All the way it goes up to one end. All the case file is one place. Now come back to my B14. Now we are talking, I'm only on interpretation. Lordship's rule of interpretation. This rule of interpretation has to be again even more a fortiori in my favor, as they say, contra preferentum, because it's a penal rule. Attorney General has based it as a penal rule. He has characterized it as a penal rule. So if it's a penal rule, then the penal statute must be read in terms of a rule of strict interpretation. This is a constitution mentions. Dilip Kumar. Just turn to it for a minute, just two paragraphs, 23, 25, which are at page 8. It is his characterization of this as a penal statute and a penal rule. Therefore, the interpretation must be strictly against that he who propounds it like this. In applying the rule of plain meaning, any hardship and inconvenience cannot be the basis to alter the meaning of the wage employed. It is especially so in fiscal statutes and penal statutes. This is a constitutional measures. Nevertheless, if the plain language results in absurdity, the court is entitled to determine the meaning of the word in the context in which it is used, keeping in view the legislative purpose. Not only that, if the plain construction leads to anomaly and absurdity, the court, having regard to the hardship and the consequences that flow from such a provision, can even explain the true intention of the legislation. Having observed, it is now time to consider. In construing penal statutes and taxation statutes, the court has to apply strict rule of interpretation. The penal, that's what I'm asking fellowships to do. The penal statute to deprive a person of the right to life and liberty has to be given a strict interpretation, or else many innocents will become victims of discretionary decision making. So far as taxation statutes are concerned, under 265, which is quoted, prohibits the state from extracting tax from citizens without authority of law. Axiomatic, the taxation statute has to be interpreted strictly, because the state cannot, at their whims and fancies, burden the citizens without authority of law. In other words, when the competent legislature mandates taxing certain persons, objects in certain circumstances cannot be expanded, interpreted to include those not intended by the legislature. So you are here trying to include, where is the section says only production, trying to include dispatch. At the outset, we must clarify the position of plain meaning rule or clear and unambiguous rule with respect to taxing. The plain meaning rule says that the language in statute is plain and unambiguous. The court has to read and understand the plain language. There is no scope for any interpretation. This salutary maxim flows from the phrase they give the Latin words. Following such maxim, the court sometimes have made strict interpretations subordinate to the plain meaning rule, etc. Then, Malas, B15. Of course, in my conclusion, I come to the next point. 12A1. Now, this is, Malas, from B16 to B35, probably the single most important part of my submissions in terms of this by itself is submission. I mean, your lordship certainly must decide constitutionally. The lordship must decide ultra vires. But this by itself is sufficient to invalid, without prejudice to all other submissions. Kindly see this thing. Now, the learned AG clearly says that it's a penalty. I'm quoting him from his submissions. I'm quoting him. Penalty for not meeting the requirement of minimum dispatch as specified under 12. That's his case. Now let us see whether now the point I'm making is 2 years and no question of an implied penalty after that. Let us see. 1A Malas reads like this. Notwithstanding anything, it's a non-obstanding. During the first 2 years from the new lease, how can there be something clearer in a non-obstant clause, which is part of the parent rule? During the first 2 years of date of execution of new lease, the holder of mining lease to whom the order was, may I skip that with lordship permission? 1A, next page. In case of shortfall in dispatch from the minimum dispatch required under sub-rule 1, well, it is entirely possible the lordship would not have used this 3 words required under sub-rule 1. You again anchor it in the previous. And the previous is 2 years. Only 2 years. It was entirely possible not to say this if your intention was different. You were very clear. I must just pause here. This is coming later. It will make sense because the idea was that he's the outgoing chair. His last has a seamless crossover to me. That's why it is taken that I must perform 80% of his last 2 years. That has to be bonus 1 or 2 years. His last 2 years, 80% cannot be valid for me after year 5, after year 7, after year 40. That is why that conceptually it is wrong. In contrast, I'm reading B18. In contrast, it must be pointed out that no such penal provision has been provided under 12A2 for the period beyond the first 2 years. Hence, the demand notices for the fourth, and most of us are in that phase, fourth, fifth, sixth, without. Now, I'm saying this one. It's a penal. So look at the intersection of 2 or 3 principles of law. Intersection number 1, penal. Intersection number 2, penal by implication. Not provided in the parent. On the contrary, specifically provided as 2 years only. And yet the consequences are penal. So you are inviting penal consequences purely by implication and subjectivity. Even otherwise, MMDR nowhere prescribes the imposition of a penalty for shortfall in dispatch. Now, this is very important because this is the section. Now, till B18 is not shown on the rule. Now, B19 is a section. 4B and 13(2)AA do not empower the state government to impose after 2 years in any case. I mean, I can't show a negative. Please pick up the section. Where is it? How do I imply it? How do I imagine it? Where is the amendment? I will go further. Where is some statement of object embedded in the beginning saying that no, we intended to be much longer, but there is some obvious cases, omissions. Nothing. Well, it is clear from my previous page. Just see, this is 12 only, same, the previous page. I'm going to take the statute, I read 2 also, 12A2 also. Let me take the statute. I put it only 12A1. Well, it's 12A1 is in the statute your lordship has got. It's the same book, it's page 474, it's rule 12. With the whole.
Yes.
So 12 capital A is the whole rule. Now 1 and 1A is as I've quoted.
Yes.
And 1 has notwithstanding anything contained in the first 2 years.
Yes.
And 1A has that thing saying
Required under sub rule 1.
So that part I'm not really repeating now. Then it gives the fasciculus of ABC, etc. Then come to 1B. This is does not maintain minimum dispatch under sub rule 1. Then 1C is a special case of hydro and atomic. Come to 2 now. So this 1C is also 1B is also under sub rule 1. I hope I don't got it. We are always anchored in sub rule 1, which is 2 years only. Now come to 2. The new lessee shall ensure that the annual production between 2 years from date of execution of new lease is equal to or more than the annual production by the previous lessee, and shall subsequently, now look at, just pause, just put a full stop there for a minute. Look at this, the remarkable. The new lessee shall ensure that the annual production between 2 years from the date of execution is equal to more than the annual production by the previous lessee. I will put a full stop there. Okay. This will match with 12A1. That my production for 2 years will be 80% of Mr. Mishra's production. He's the previous chap, outgoing guy. Now, it is clear that the subsequent is not a requirement of compulsory dispatch. It is a working out in the light of your market conditions, in the light of reality or in the light of IBM prescription. See the way it's done. And shall simply work out and implement an annual production plan to ensure that the mineral resources are fully exploited during the period of the lease, failing which appropriate actions in accordance with the MDPA shall be initiated. Now it makes complete sense for us. For 2 years, you are obliged to follow a prior outgoing person's anchor. Now forget 2 years, we're not talking of 2 years anymore. After 2 years, you, Mr. Singhvi, who's the incumbent lessee, naturally will work out subsequently what is important and your production plan to ensure that mineral resources are fully exploited. So you are not hoarding, you are not artificially creating scarcity, which is exactly what the IBM tells me to do. Now you have full harmony. So the harmony is exploitation also is not ultra low, but exploitation is also not totally without sync of your market conditions, need, necessity, and environment. That's the balance. And it is clearly made out if you read it like this. My letter reads it in a manner which cannot possibly by any stretch of distortion be read, with great respect. Please distort it in any which way. How do you read this to mean that what you do in the first 2 years on a prescription, I am reading here year 3 to 50. In a penal, well, in some kind of a casual thing, the lordship may read something into it. This is a penal consequence. How can it be a big thing? So, if you just on, now I'm only on facial, I'm not on law yet. Textual and facial alone. Obvious. Just textual and facial. One, that 12A1 was intended for 2 years. Two, the source, the mandate, the power is for 2 years. Two, if that is right, everything else is ultravirus beyond 2 years. Three, the structure of 1A and 1B, structure it, anchor it back into 1, which is 2 years old. Four, subsequent to 2 years, you will work out a plan which is both an implementation and yet you will ensure that there is no artificial created scarcity. And 5, it's done. That is why they are complaining internally that we are doing this planning. Why we put a superimposed external force like this? So this is why I'm saying this is
Why the proviso was inserted after subsection subrule?
Provided, I'm sorry.
That's
the
along the
new
third
lessee
amendment.
shall also ensure that
That's
at
the
least
third amendment,
80%.
1721.
This is very now. This is perfectly well in sync. This comes as a lordship notes in June 21. In June, this is to 80% of annual production. Both it will apply both for 12A 1A for the first 2 years, and it will apply for whatever you work out to be the right figure.
No, there are two things.
Yes.
Let me understand
Yes.
for the purpose of the clarity.
Yes, certainly, certainly.
If I clearly understood your submissions in this regard is
Yes.
that so far as Rule 12(3) Subrule 1 is concerned, it is operative for a first period of 2 years when he stepped into the shoes of the previous leases.
That's the rationale.
That's a way that you have to maintain the average annual productions up to 80% of the previous leases.
Correct.
You say that so far as the 1A, Subrule 1A is concerned, it is always controlled or somehow related to Subrule 1,
Which it says.
which talks about the 2 years and not beyond that. Then you say that EB also
One
about
is
the Subrule 1. So it is all relatable or to some extent attached to or controlled by Subrule 1.
And limited up to 2 years.
Limited, controlled by Subrule 1, which is limited for 2 years,
Obliged.
not beyond it.
Obliged.
Then you say the Subrule 2, when it is there.
It's talking beyond 2
There
years.
are two, yes, beyond 2
It
years.
says so, the first line.
There are two things. One is up to 2 years,
Over.
your obligations are there. You have to maintain. Beyond 2 years, according to you, has to be worked out subsequently by you, and then ensure that the minimal resources are fully exploited during the period of the lease. So if the period of the lease is
3 to
say for
50.
50 years,
3 to 50.
so after the expiration of the first 2 years,
3 to 50.
from 3 years to a 50th years,
Correct.
you have to work out,
Obliged.
you have to analyze,
Mm.
then how you will go on
So-
an optimal production
Yes.
of the.
So you will make a plan that in
That means this is a period between 3 to 50. But if you come to
I explain the proviso.
in a proviso, it talks about ensure 80% of the annual production is dispatched in the said year, not it has used in the plural form.
No, said here would be because the
Means
proviso.
that each of the year from 3rd to 50.
Yes, I have no problem. I'm reading it as years. If you also have that issue.
There's the General Clauses Act.
No, I'm
Sometimes the
reading it
plural
as years. Your
means
Lordship need not make
singular
fun
and
of-
singular means plural.
Exactly. And your Lordship need not be bothered about that. I'm reading the word year to be years. And
Yes.
I'm reading the proviso to be 3 to 50. Now let me answer the thinking, the harmony. Straight away. I'm very grateful for the query. So we are okay, well, still summarize till now. I'm now going only ahead. My lords put to me that 2 is clearly beyond to agreed, Malus, absolutely right. 2 Malus clearly has a mandate which is different in language from 1. We have just seen it. There are 2 Malus, same sections, they're totally different language. It requires me to subsequently work out and implement an annual production plan, which will be not the same for me as for him. It's not a one size fit all. The lessee will work out. It can never be one size fit all. One size fit all is one. Each lessee will work out and implement an annual production plan. Now, Wallace, that plan is worked out broadly on 3 features. 1, on the market conditions. 2, on optimum utilization. Now, 3rd is safety and fast depletion, overfast or overflow. A caveat is given that Mr. Singhvi, when you work out that plan, you must ensure that mineral resources are fully exploited. That's the caveat when I work out my plan. So far, Manoj, I'm with now my lord puts the second proviso to me. Second proviso, sorry, the proviso to this second section, subsection, only means this, only that in the plan you work out, Mr. Singhvi. So I work out a plan that in the year 1, that is year 3, I will do 10 units. Year 5, I will do 50 units. Year 10, I will do 100 units. You must you must dispatch at least 80% of that plan. So my production plan has to be that year 1, sorry, 1 year, okay, 3 to 5 is 10 units. 5 to 10 is 50 units. 10 to 15 is 100 units. But if you, Mr. Singhvi, say this in production, please make sure by the proviso that 80% of that 100 or that 50 you must dispatch. It completely fits it. It completely fits it. As opposed to a very strained construction that till year 50, well, just imagine, you will be one size fit all, governed by what Mr. Mishra, the outgoing lessee, produced and apply 80% of that, by which time in the 39th year of the 40th year, the whole world would have changed. Well, just imagine, suppose we are now, Mr. Trump is finding new rare earths everywhere, etc. We find new rare earth minerals, and steel itself may be substituted. I'm giving an example. Steel itself may be become marginal. I don't think so, but it can. Some new substance can come. What will I do with iron ore? I will follow this pedantic plan for 50 years. Just to satisfy somebody's ego, that, you know, I've got a plan in. So it is inconceivable that I was supposed to throw Mr. Mishra, who has long exited and gone. And now come further, there are more reasons coming. So the sink of proviso is this. This is very clear in my submission as far as I'm concerned. That is the sink. That's the harmony. But there are more reasons coming. B19. Even otherwise, the MMDR Act 57 nowhere prescribes the imposition of a penalty for shortfall in minerals. This I have made a very point. Please point out to the Honorable Court where is this penalty. On the one hand, learned AG is saying it's a penal provision. But it must be specific. It can't be implied. He is actually arguing implied penalty. Now, where the Act wants a penalty, provides for it. We have no problem. Take, for example, 21 of the Act. There's a provision. Nothing to do with this case. Suppose when I start going and mining in somebody else's lease, or I start doing something in next door neighbor's lease, there's 21 of that. So they are conscious of penalty. But on the other hand, by implication, they don't create a penalty. Now, B20. This is very obvious, but extremely well. Sometimes the obvious has to be stated because the government of the state and the government of India don't seem to think that it's so obvious. No rule can be framed for imposition of a penalty to subordinate legislation. Like this one. Here in this case, implication. I'll not read these many cases, but just note Bhagwati as one, the last one. This is Nariman speaking at page 15 of that same volume 3. All are important, not to the fourth one. We are forgetting that we are in the realm of penalty. And this is your own case, not my case, your case. If penalty can only be levied by authority of statutory law, what is the meaning of all these principles? Here, you are in fact implying, far from statutory, you are implying even in delegated legislation, you are implying things. That no, it will apply from 3 to 49, etc. That's also an implication. A penalty can only be levied by authority of statutory law. And the Act, as has been extracted out, does not expressly authorize the government to levy a penalty higher. This further shows that imposition of a mandatory penalty equal to the amount of not being by statute would itself make rules. Now look at the number of rules, boys. ZO, ZP, ZQ without authority of law. We uphold the contention that all these cases strike down the rule in so far as they impose a mandatory penalty equivalent to the amount of duty on the ground that they are violative of 14, 19, etc. etc. Ultra-wise. Then B21. As evident from the language of Rule 12A2 itself, which is a rule of in the event a lessee petitioner has not been able to meet with the set targets, action can be initiated in accordance with MDPA. Now, this is quoted, brothers. You also have seen it. Don't read it, just note the bold face. Appropriate action in accordance with MDPA shall be initiated. This is another very important aspect which is being forgotten by the respondents in their entire stand before lordships. If at all penal action is contemplated, one category is section 21, when I start encroaching on somebody in these, etc., etc. The other is equally occupied field provision. For example, the MDPA occupies the field. It provides for a appropriation of the performance security I have given to you in the inception up to a cap of 24%. So, if you do something which is wrong, you have inbuilt occupied field penalties, either a 21 penalty or the MDPA penalty. Just show the MDPA penalty. I'm sorry, I quoted it. I'm sorry. The next page is quoted. It's quoted. Now, here you have done that. We are not fighting on this. I'm not saying the lordships can't have this against me. You are now invoking something else, compulsory dispatch on pain of penalty. Under 1A. Not this. This is what is provided, contractually written. You give it the go by. Year since, and this is also year based, year 3 onwards. Value of performance security. This is the same subject, but the lordship notes the language, very important. The left hand column says year 3 onwards. Refer to A. And then see 24% of average sale price of relevant mineral published in IBM as applicable during the year of shortfall multiplied by shortfall, etc., etc. The minutiae doesn't concern my lord. The concept is clear. If you violate this, I will take up to 24% of your performance security, whatever it may be, based on average sale price. This is what I will note, B22, it's called Schedule D of the MDPA. And incidentally, you are swearing and living by the MDPA again and again. When I argue mining, I can't argue MDPA. This is your MDPA which provides a penalty, not the penalty you are asking now. Thus, in terms of rule, I'm reading B23, 12A2, the action by the state could have been only limited to the appropriation of the PVC to the extent of 24%. Explicit remedy as contemplated under the rule itself cannot be overreached by the state by relying on 12A money. They must try to attempt, because they're all part of the same house. They try to now save it by saying, read 12A in the light of a combined holistic reading of 4B, 8B, and 13. This is the argument. Let us do that. This is my submission in response to them in the alternative. What I've argued is something else. Now I'm saying in the alternative, assuming without conceding. Assuming without considering the phrase sustained production in 4B includes dispatch. Now, I hotly contest this. The Lordship will not, and my submission, hold sustained production to mean dispatch. But now I'm arguing against myself in the alternative. The moot question is, can subordinate legislation impose an obligation of compulsory dispatch and impose penalties on basis of notional compulsory dispatch? I'm arguing this point now. I made an argument on this point in B25, which is not answered by them, not addressed by them. Forget right or wrong, not addressed by them. They've not rebutted it at all. My argument was this, and B25, 12A imposes an obligation of notional compulsory and introduces penal consequences, which is ultra vires all the sections 9B to 9 to 9C. I submit that 12A imposes an obligation of notional compulsory dispatch in the event the lessee does not meet a particular target of dispatch in a year. The executive would impose prejudicial penal consequences by imposing payments of royalty and all the others 5 things Lordship boards, DMF, NMET, bid premium, all on the notional dispatch removal target, whether such is actually dispatched. Dispatch is clear. If you apply it, it is clear. It applies to not only the royalty, it applies to all the other components I have listed. On this point, I say facially and textually, 12A travels beyond the sections. This is ultra vires classic, old classic argument of ultra vires, not answered by them. Not answered, not attempted to be answered. Not attempted to be rebutted. 9. The holder of a mining lease granted, etc., shall pay royalty in respect of a mineral removed or consumed by him or his agent from the leased area. Actually, this has to be about actual removal, not notional. I'm now arguing notional only. Your act falls on notional compulsory. My argument of ultra vires is based on that your act nowhere allows notional. Any reading of removed or consumed must mean actual consumption or actual removal. Now the same words apply to the DMF 9B, capital B. Shall, in addition to royalty, I'm reading 9B middlemen, pay to the DMF an amount which is equivalent to such percentage. This is obvious because it's not a percentage of that. So the first one is there, all of them are on the.
It can be said to be somewhat dependent upon my.
I'm grateful. Consequent. I'm grateful. I'll not read it. 28, next page. It is axiomatic that delegated legislation of any kind, and 12 capital A is clearly delegated legislation, cannot alter the fundamentals or conceptual underpinnings of the main section 9, 9B and 9C. No submissions were advanced by either of the learned AGs on this. What should we note on the side? On this B28, the law is below in B31 and B32. It's a little disjointed, but Lordship will get the law after 2 paragraphs. Let me finish reading in sequence. The law on B28 is at B31 and B32. But let me continue. By no stretch of imagination can it be said that conscious or voluntary non-dispatch or non-removal by the lessee has been prohibited. What is the meaning of this kind of pause? What is the meaning of compulsory notional dispatch? I give you a figure externally like a order of Farman that you must dispatch 10. It is common ground that this has nothing to do with what you actually dispatch or consume. It is common ground. Now, if you do not dispatch more than 8, you have not dispatched 2. I treat those two as having been notionally compulsorily dispatched because it's my farman to you. On those two, I will levy. Now, where does your 9B or 9C catch those two is my question to myself. Where, because ultimately you are saying that it is somewhere in the line. Now, that nowhere says because it's a removal or consumption. Doesn't use the word notional, doesn't know the word deemed, doesn't know the word shall be assumed to be, nothing. By no stretch of imagination can be said that conscious or voluntary non-dispatch by the lessee has been prohibited. In this context, I have taken the liberty of quoting a question which fell in the hearing of my Lord the Chief Justice. During the submission as to whether a lessee, the Lord should ask this question, could circumvent the obligation under 9 by removing minerals from the lid and not further dispatching. This is a separate but practical aspect the Lordship asked a ground reality. It's very important. That I am removing, but when I go and hide it in some warehouse or put it somewhere in the forest or something, I don't dispatch it. In other words, is there a regulatory framework to regulate removal dispatch? Is there any regulation on whom lessee can dispatch to?
There is. The trading you cannot do unless you have a.
Not only that,
the
it is
permit of the
one of the
license.
most heavy, well, your Lordship knows that by the most stringent law against kidnappings or assaults or murder, your Lordship still have murder. I mean, you will not have the, but there cannot be a more stringent regime in answer to your Lordship's query, which is coming next. Answer. Just kindly see the answer. All aspects of removal dispatch are fully regulated in the scheme by way of rules framed under 23 capital C. In Orissa, these rules are called the Orissa Prevention of Theft, Smuggling and Illegal Rules of 2000. They were created for this purpose. The question my Lord asked led to the creation. Well, may I just digress? This actually happened because of Bellary. Very time. There's a lot of things happen in Bellary that you would have production, you would even have a removal, but you would not have the market reaching. So that led to discussion, and 2007 rules were created in that context. And in Orissa, they have plugged the rule completely. Although they started with, I don't know whether they plugged in Bellary or not, but here they plugged it. It's kindly see. Under the OMPTS rules, if the lessee wishes to remove any mineral from the leasehold area, look at the things I have to do once. I have to apply in Form J for a transit permit. That must disclose the quantity, stack, grade as determined by a sampling process. Then after this J application, the government on being satisfied will issue a transit permit to me for removal of ore. Then after advance payment of royalty, advance is under Form L. This again contains quantity, stack, etc. And the title of the rule is the Prevention of Theft, Smuggling and Illegal Mining.
Yes.
Exactly the same title. All aspects of dispatch thereafter, a person to whom it will be dispatched, the manner of the transport, the name of the truck and the rail, fully regulated in great minutiae by Rule 10 and is implemented seamlessly. Now they have an online tracking system called I3MS, which is good because all this is good. All transit permits, licenses, passes are issued online only after advance payment of the levies in the absence, which cannot be dispatched beyond the overway bridges and mining. If your Lordship is asking a question that liquor, for example, do you have any smuggling? Of course, you must be having. Much less so here, there must be some. But that doesn't take away from the fact that it is not easy to take away trucks like this, as your Lordship might have been told or imagined that, look, a lot of these things are happening that you are. So, what is the purpose you are serving? You are not serving any great purpose that people are producing hordes of this iron ore, keeping it stored up. No, nobody is foolish enough. Take, for example, my company in this case. Don't take any of these. These are reputed companies. They will store up and then go and smuggle it to some place. And for that assumption, far-fetched, you are now saying no on compulsory dispatch, otherwise pay penalty. So we are living in some kind of a Kafka kind of a imaginary situation. This is the law I was talking about. I'm sorry, B30 is the severe adverse civil consequences. The 31 and 32 is the law for para 28. Namely, that subordinate legislation cannot create. So at the highest, you are saying 12 ways creating. Please show the court where 12 ways creating under etc. If it is not there, then it can't create. It can't create. Kunj Bihari and global. And then traveling beyond. They both go together, 31 and 32. Tamil Nadu and Indian Express. Just see for a minute, Kunj Bihari. Now this Kunj Bihari is in the second volume, same volume. Second.
There's a
What you were using or the other one? But not the one you're using, the other one.
volume 2.
Oh, these are documents.
No.
These are- these are continuous
Case law has two volumes. One is you're actually using the case law extract. There's another case law extract. It's called volume 3. You sure it's 3 or 3?
No, the volume 3.
In the case law extract.
Digest.
Digest.
Okay.
Kunj Bihari Butel Malas.
Yes.
It is very common for the legislature to provide for a general rule-making power to carry out the purpose of the act. When such a power is given, it may be permissible to find out the object of the enactment and then see if the rules framed satisfy the test of having been so framed. This is find the object of the enactment, then see if the rules framed satisfy the test of having been so framed as to fall within the scope of such general power confirmed. If the rule-making power is not expressed in such a usual general form, it shall have to be seen if the rules made are protected by the limits prescribed by the parent act. This is another way of putting the ultra-virus doctrine in a very pithy way. Then they cite a lot of cases. This is Lahoti speaking for the bench. Then para 14, lower part of the page, they are also of the opinion that a delegated power to legislate by making rules for carrying out the purpose of the act is a general delegation without laying down any guidelines. It cannot be so excised as to bring into existence substantive rights or obligations or disabilities not contemplated by the act itself. So I can always tell, I'm sorry, my lords, 4B, 9B, 9C don't have the power. I concede. But there's a general power saying you can take out rules for carrying out the purpose of the act, and these rules are under their power. That has been debunked many times. That would be literally encouraging ultra-virus action. Whereas global energy is the next page. It's just the first part, the highlight portion we have. Rule-making power for carrying out the purpose of the act is a general delegation. Such a general delegation may not be held to having laid out any guidelines. By reason of such a provision, power cannot be excised. Same point. And then the next item I will not read. I think the same thing. Just note Express and State of Tamil Nadu in my para B.32. They're all here. The Express is at page 5. This is a different Express, not that Express. Now Rashid comes to B33. Now B33 is just a citation for summarizing the ultra-virus principles, which I read in the opening. This Naresh Agarwal, I read in the opening ones. So Rashid did not read. B33. Now come to B34. Rule 12 capital A is, however, not a case of provisions of MMDR Act being a general, broad, enabling, empowering provision. With the detail, the Lordship has no ultra-virus where I give you the power and you have the detailing in the rule. That is a different case where the power doesn't exist there, but the substantive levy is born for the first time. That's the point I'm addressing now. This is a case of conceptual contradiction of the main section by a delegated legislation, because the former permits full volition in the lessee whether or not to dispatch, whereas the latter compels the lessee to remove dispatch upon pain of penal prejudicial consequences. This and whereas the next para on the next page are the summary of the entirety of the ultra-virus point. There is no provision under the parent statute which provides for a direct or indirect, express or implied mandate penalizing voluntary non-dispatch, non-removal, as has been done in 12A. On this score, 12A is ultra-virus. And this point has largely not even been addressed in debate. Not even addressed in debate. This paper is not much after that.
Yes.
page 11.
Hmm.
The submission of the respondent and the legal is that the demand notices levy the influence of all the other items also, premium amount for paying the user. This is the same thing as my submission is that Advocate General further contended that the demand notices comprise these three components, all of which are in the nature of imposed constituting consideration for the mining units. This is a new aspect. He's trying to add on to this. My answer is clear, Malas, that these imposts which are listed there are also levied only on the actual removal dispatch. The sections are quoted. Therefore, all the arguments I made apply equally. Mutatis here also. Upon actual removal, I'm reading B37.
Hmm.
The lessee discharges liability towards premium, royalty, DME, and NEM, and upon such payment, transit passes are issued. However, by virtue of the demand notices, the imposts have been made even in the admitted absence of removal dispatch.
Next to you.
At the time of actual dispatch removal, this is the doubling. So, what should look at like in the example in the opening. As per year, let's just say calendar year for simplicity. This calendar year of 2025, my actual production is 10. Minimum dispatch is 12. I have not done 2. So I'm penalized for 2. So I have to pay whatever is required to pay for 2. Next year, when I actually dispatch this 2, I again pay. I'm talking about dispatch of the same 2 of last year's. So there is clear doubling rules. And unjust enrichment, which is what I'm saying in B38. This is Manas in my original submissions, E1 to E6, page 27 to 30, or actually on the side. That's in the opening submission. You need not go to it, just Then Manas vague or arbitrary. The learned attorney says this in C1. There is no vagueness or conflict between these two requirements. The new lessee is required to meet both the requirements. That is, his production should be more than the average annual production of the previous leases in the 2 immediately preceding years. Mark these words. In the 2 immediately preceding years. And is also required to maintain. Well, at greatest respectability, where do you get these 4 words? Can anybody who has argued on the side point out anywhere these 4 words? This is imagining what is required to prove. It is assuming what you seek to establish. It's getting the issue. It's a very self-serving formulation to put the words 2 immediately preceding, there's no such word. After the first 2 years, which is 1A, there is nothing. With utmost respect, the expression 2 immediately preceding years is not found in A2. That's the debate. If that debate is solved by your imagining these 4 words, then there cannot be a debate. It's found only in 12A1 and not in Rule 12. That's the whole issue. Then I've quoted, well, it's obvious. I'm not going to read it again. I've read it twice already. 12A1, yes, it talks of immediately preceding 2 years. Then 12A2, lower quoted, is totally different and subsequently work out with my Lord as well as I've labeled at some point in the pre-lunch session. And what is the logical? Thus, the rule maker has consciously and deliberately used very different expressions in 12A1 and 2. While the obligation under 1 related to the average of the annual production of the 2 immediately preceding years. This phrase, the learned AG stands, plucks out from 1 and plants into 2. The obligation under 12A2 is qualified by 2 expressions. Annual production of the previous lessee, presumably without prejudice, and not the last 2 years. A subsequent annual production plan to ensure resources are fully exploited. Therefore, Rule 12A2 places primacy on a subsequent production plan and is very, very, very important to be approved by the IBM. It has nothing to do with the production by the previous lessee, the previous student. Incidentally, Rosham should not think that I can produce 100 and 1 year suddenly jerk it down to 10 and next year again jerk it up to 50. It's entirely regulated by the IBM. I'm not a master of my own volition in this respect. Thus, the submission in C.5 is erroneous. C.6. Now, this fellow is a very simple but inconvenient truth which you have not answered to the Honorable Court. This truth is your own truth, your own document, not mine. But you've not even addressed it. Now, but we are saying it is vague. You cannot apply it. This is what your IBM says. Your IBM says C6IB. C6IB, I quote it for convenience. Annual production of previous lessee, whether over the entire period or any special period, has not been defined in 12A2, which creates confusion in defining the future production. You know what am I saying? Same thing. Arbitrary, vague, undefined, well, it's discretionary, subjective. They are saying the same thing. And you are faulting me for that. Your own IBM is saying it. Then another 24th April is the state says the same thing also. Very important. The state says it. The state is lamenting. I don't know how to calculate. Please tell me, sir. I don't know how to calculate. Now it's a very long one, but I will not read all of it. Do it just close. Several new lessees have submitted representations indicating the difficulty. The difficulty, forget what is listed, ABC. Come to 12. The question therefore arises as to whether the preparation and implementation of this should be done in strict adherence to Rule 13, etc., by suitably harmonizing all the provisions. Therefore, requested to kindly examine the matter, provide necessary clarification, whether the state government is competent at its level to fix the annual production dispatched. They're asking a simple question for the new lessees of expired mines for the period from the third year onwards by suitably harmonizing the above seemingly contradictory provisions to ensure sustainable and scientific mining, same time keeping into the adequacy of supply of minerals to the consuming industry and the interest regarding revenue generation, subject to a revision at an interval of 5 years or any other clarification which the ministry makes. Well, there cannot be a more strong request in diplomatic language. Very clear what I am saying is not an imagination or in the air. This is a genuine problem. Now, as the Lordship notes the point, before I read the next section, that there is the entire thing which we are arguing, entire thing doesn't apply to greenfield at all. That's the admitted position. Now, is that an invalid classification? Is the issue. I argued it is. The answer is when AG gave was that there is an intelligible differential between the two. Let's look at the intelligible differential. There is none. From the year 3 which we are concerned, there is none. The Attorney General has submitted a distinction greenfield and brownfield. I quote him on this. Greenfield mines take up to 5 years and a further 3 years to commence. This is factually and legally incorrect. Both factually and by law. So first you prolong it to 8 years. There is nothing, it's given in the writing. Just see that next quotation. Rule 10 says, subclause 4, quoted by me, the successful bidder shall sign the mine development, etc. agreement with the state government after obtaining all consents, approvals, permits, no objection, the line. So when the MDPA doesn't get signed till you got already the permission. The time is not after that is run before that. Page 15. The successful bidder shall pay the third installment of the upfront payment subsequent to execution of MDPA. And upon such payment, the state government shall grant a mining lien. So all permissions first, MDPA later, payment third, and mining fourth, and mining lien must follow on the payment. That's the sequence. The mining lien shall be executed within 30 days of the conditions specified in the previous clause. There's no 3 years and 5 years, 8 years is what the AG is saying. That's not right. Provided that no mining lease deed shall be executed on expiry of a period of 3 years from the date of letter of intent. On the contrary, the other way around. Your outer limit is 3 years. Failing which you lose the right. Well, I can't issue LOI to you and keep you hanging in the air. And the letter of intent shall be invalidated, leading to annulment of the entire process of auction. Is the other way around exactly. In 3 years, a so-called greenfield becomes an existing incumbent mine. Max, 3 years is max. Could be 2 years, could be 1 year. Now let us see my submission. C9. Therefore, under 10(6), a time period of 3 years, extendable at the state government's discretion, is granted to greenfield to obtain all necessary clearance and execute the money. Crucially, this is my very, very important submission. Just double take the lot you made. C10, C11, and C12 are 3 important submissions. Once the mining lease is executed, greenfield leases stand on the same footing as brownfield. What I said to your worship. As they are also then completely capable of commencing mining operations. In 4A4, which deals with the consequences of lapsing for failure to operate, it applies without distinction to both greenfield and brownfield. Thus, once a mining lease is executed, the distinction between brownfield and greenfield evaporates. What distinction exists only prior. Namely, brownfield are given the benefits of automatic vesting and greenfield are given 3 years' time. Now, whereas the arbitrariness is writ large in C12. An oppressive regime is there from year 3 to 50 only, repeat, only for brownfield. Not a word about green. Whereas you are operationalized in the 4th year, maximum is the 3rd year, in the 3.5 year, in the 4.5 year. But you are operational in 3rd year, you continue uninhibited by all this. And I am continuing till 50 years to be governed from the grave by these rules which have no relevance. What is the difference between me and you? Because you are next door to me. The greenfield and brown next door they can be. Once the man gets the greenfield in 3 years, we are continuing next door to each other for 50 years. He has no regulation. I have regulation for 47 of the 50 years. How is that an invalid distinction? How is that? What is the intelligible differentia? Well, I with great respect. Intelligible differentia may be in the first 2 years. We are not even talking of that. If at all it is there, maybe in the first 2 years. Let us leave a 3rd year. If you get a mining lease, which you must get in 3 years, then what is the differential? C13. Just a answer rather than a blanket way saying intelligible difference. No reason is given to your lordship. Yet the oppressive and prejudicial regime of A2 applies singularly only to the category of brownfield leases. There is no rational nexus applying A2 only to one class and not applying that to the other. That too for a humongous period of 48, it should be maybe 47 years. By way of example, greenfield or virgin leases are under no obligation under any rule to compulsorily dispatch minerals for the entirety of the lease period. And look at the amount of saving. Look at the amount of undue advantage you are getting. You are starting a race next to each other. You are making it completely impossible for me to compete with you. He pays 0. Now, where is the other most important point? One was that point about 12A1. Now, other point is mining definition, mining plan. In this part itself is sufficient. One is your lordship has the constitutional validity ultra vires. That is very important. But these are sufficient to invalidate. This is sufficient to invalidate within the statute, without going to the constitution. The mining plan is a vital linchpin, and this includes everything. Well, the mining plan can include that you this year you Mr. Singh will do 0. I'm giving a theoretical, not that. This year we expect some safety issues, we expect extreme blood, whatever. We expect some major crack to the mine. 0, you do 0. Maybe I will then file a surrender. This year you do 100. This year you do 20. Now let us see what this mining plan is. This mining plan is brushed aside before your lordship by saying it's a technical. These 2 words. That one whole argument brushed aside by penumbra. This is brushed aside by saying technical document. Well, I wish it was so easy to brush aside the law. The mining plan is the vital linchpin, foundational document of all mining regimes. At the outset, it is submitted that mining plan is a creature of the Act. Now let us see what is this creature. 5(2)(b) is the one of the sources. MDPA is of the rules. Therefore, the contention that the Attorney General that the mining plan is subservient will express subservient. How can the rules be higher than the something sourcing itself to come to? If the reverse is true, exact reverse is true. Now your lordship has no res integra on this. Your lordship need not labor on this. It is covered not once but twice by strong words by the Supreme Court saying sacrosanct. What I am saying is not my saying. It is the Supreme Court saying it's closed it for the High Court, closed it for itself. Not at all res integra. Let us see. The Honorable Apex Court in Common Cause has held that the mining plan is sacrosanct and a sine for the grant of a mining lease. And just come in a minute. The mining plan comes into operations only after the approval by the apex scientific, technical, and statutory central government regulator, the Indian central government. Your Lordship ultimately is the master and the owner, because everything in this act is done through the agency of the state. Do not forget entry 52 and 54, where you are the master. In fact, your declaration in your parent statute denudes everybody else in the farm. The state is acting only as a operational collecting agent of implementing. The state can't go on mines and minerals against the central. Central government is only one body, one and one only. Speaking for it in expert technical terms, IBA. Now, before I go further, just give me 2 minutes on this 3 or 3A. 3A was common cause. You see, common cause.
Justice Lokur's judgment.
My lord is right. Great respect. That's very important. I had the privilege of assisting the court. It went on for many days. The Gopal is also there. And this is Lokur's judgment, my lord rightly recalls. In the so my lord will first turn to 71. He goes into great length and great detail, but just see. There's some few portions. 22A of the MCR makes it clear that mining operations shall be undertaken.
Paragraph
71 is the one which is there in your lordship's page 15. The my lord is 15.15 of volume. So you also seeing the actual judgment?
Yes.
Actual judgment. Or you also seeing my digest?
No. Actual judgment.
Actual judgment. Sorry.
Yes.
So my lord,
Read 22A.
71. Rule 22A of the MCR makes it clear that mining operations shall be undertaken, get the judgment, only in accordance with the duly approved mining plan. Therefore, a mining plan is of considerable importance, mark these words, for a mining leaseholder and is in essence sacrosanct. A mining scheme and a mining plan are a sine qua non. So 3 phrases here: considerable importance, essence sacrosanct, and sine qua non in one para. Para 79. Rule 13 of the MCDR provides that mining operations are actually carried out. I'm reading para 79. I'm sorry.
Yes.
Mining operations are required to be carried out by every holder of a mining lease in accordance with the approved mining plans. Must be carried out. If the mining operations are not so carried out, the mining operations may be suspended by the regional control of mines of the IBA. In our opinion, I'm sorry, my problem.
Yes.
Now, I will jump to the lordship permission to 151. 151.
Yes. Yes, in our opinion.
In our opinion, 21(5) of the MMDR Act is applicable when any person raises without any local authority any mineral from any land. Look at the width. Any person, any land, any mineral. In that event, the state government is entitled to recover from such person the mineral so raised, or where the mineral has already been disposed of, the price thereof is compensation. The words any land are not confined to the mining lease area. As far as the mining lease area is concerned, extraction of a mineral over and above what is permissible under the mining plan or under the EC undoubtedly attracts the provisions of 21(5). of the Act, being extraction without local authority. Also attract 21(1) of the MMDR Act. In any event, 21(5) of the Act is certainly attractive, not limited to a violation committed by a person only outside the mining area. It includes a violation committed even within the mining area. This is so because the MMDR is intended, among other things, to penalize illegal mining on any land, including land, and also preserve and protect the environment. Action under EPA or the MCR would be the primary action required to be taken with reference to the MCR, etc. Read with the explanation. But that cannot preclude compensation to the state under 21(5) of the MDR Act. The MCR cannot be read to cover the MMDR Act. Now, I want to ask myself one question, if she doesn't mind. Something which the Supreme Court is saying sacrosanct, sine qua non. The entire written submission dismissed it as a technical document. Supreme Court says sacrosanct, and your lordship's written submission in writing by the respondent says technical document. It's brushed aside. There is one judgment which I have not given my experience, which is a prior judgment, prior to Justice Lopez, which has some relevance to the same issue. It was part of the MC Mehta series, 2009 6 SCC 142. 2009 6 SCC 142. Para 20 will suffice. Now, we are understanding, wait, this is 2009 verse. What is the mining that piece of paper? It's something which is, yes, a circular, a departmental objection which can be brushed aside. No. Mining plan is prepared with the object of providing a systematic working plan of the mine after considering, look at the words, every aspect of the background information, plant, machinery, method of working, object of mining, operation and reclamation of mined out areas. This will take place over a contract. MDPA is contractual. This is tracing itself to 5(2)(b) a statute. It is a mandatory document, mark the word mandatory, comprising information about leasehold area, showing nature and extent of the mineral body, prospecting data, details of geology, including mineral reserves, method of mining, manual mining, mechanized mining, nature and extent of water bodies, forest areas, density of trees, protective areas, environment impact assessment of mining activity on forests, land surface, details of ecological restoration, land reclamation, use of pollution control devices, and plans for excavation from year to year for 5 years, and such other matters and measures as may be directed by the central government, so and so handbook, etc. etc. The concept of mining plan applies to us. This is beyond comprehensive. Can your lordship imagine that something like this can be treated in the cavalier manner in the central government also, only because it doesn't, the central government's entire case will fall if they don't dilute the mining plan. Don't wish it away if they don't trivialize it. That's why the stand has been taken. And what is astonishing, the stand is taken by the central government whose body is the IBM. It is ultimately part in the broader sense of Ministry of Mines. It's unfortunate, and your lordship judgment predicated on such submissions. It means that your lordship is really being asked directly, without any regard to established law, to undermine the sanctity. What will happen to precedents by the lordship judgment quoted there? Mining plan is this, mining plan is that. It's not that lordship decides only my case. Now else, kindly come to D5. The mining plan is required to be approved by the central government's main and only regulator, the IBM, dealt with in Rule 10, named under Section 18. Now, just note 3 things here, or should we digress for a minute? Pick up the act, kindly. 5(2)(b) for a second. Twice, we have the quotation. Kindly skip a few paragraphs. The quotations are here. You can see where I should find. D5, D10, sir, D10. I quoted it. 5(e). This is the statutory source. Your statute is recognizing it. Does my lord have this para detail? 5 to B. Now, the rules which specifically talk of it is Rule 10. Rule 10 is there under Section 18, which is also quoted by me. Turn the page to page 18, Manas. 18. After the all the thing is given, mineral development, etc. Come to 18. I'm sorry, you just come to 17 bottom. In particular, without prejudice, generality of the foregoing rules, such rules may provide. Now come to 18. The opening of new mines and the regulation of mining operations in any area. The regulation of the excavation of collection of minerals from any mine. And then comes the mining plan specifically mentioned below this, Rule 13(2)(f). F for father. Mining plan, no mining operation shall be undertaken except in accordance with the mining plan. It's a blanket prohibition. And this is only a scrap of paper when it comes to your putting compulsory dispatch. Now, the very essence of mining plan is this is the way of nicely doing mining, less, more now, this month more, this month less. A whole 10-year period is given. And this will take care of environment, this will take care of supply, etc. Suddenly comes the compulsory dispatch requirement. It's a bull in a China shop, but it's directly in the China shop. No mining operation shall be undertaken except in accordance with the mining plan which A has been approved by any officer of the Indian Bureau of Mines, duly authorized in writing by the Controller General IBM, pursuant to 5(2)(b). Well, if the Lordship had any doubt about the statutory nature, this is answered here. Pursuant to 5(2)(b. and in accordance with 15, 16, and 17. In accordance, and it is all the system established at that. The mining plan shall incorporate a tentative scheme of mining and annual program for year to year for 5 years. It's like a 5-year plan at least, and keep getting modified and now come to the next. Same rules. Same rules. Now, you can say, oh, nothing's come, it can change. Modified, see what you have to do. It's very serious. Modification and review. The mining plan, once approved, shall be subject to review and updation at an interval of every 5 years. So, first of all, it's largely a stable document for 5 years. And let's see what happens. At least 180 days before. Look at the difficulty. It's very, very important. You can't even modify stats easily. This you can't. At least 180 days before the expiry of every 5 years, the lessee shall submit a mining plan for mining operations for a period of 5 subsequent years, prepared in accordance. So, 6 months before the 5-year expiry, I must give for the next 5 to 10 years, in accordance with 15 and 16. Then 3, a holder of a mining lease may seek modification in the approved mining plan, as are considered keeping in view changes in the business environment, or for facilitating increase in production capacity, or in the interest of safe and scientific mining, or for the conservation of minerals, for the protection of environment. So it's a very holistic perspective. This compulsory dispatch is literally a bull in a China shop. It's a superimposition without any regard to the nuances. Then verse 29, put it below that. This is the same rules, MCR. Conditions of mining lease. Every mining lease granted pursuant to Rule 27 shall be. So, my mining lease says, to Mr. Singh, you have a mining lease, you cannot do C, below C, except operate the mine in accordance with the mining plan. So, the mining plan becomes a part of your guideline in your mining lease, and mining lease will become a cancellation if you don't do it. Now comes a different rule, MCD. There was MCR, concession was MCDR. Conservation and Development Rules. 10. Competent authority, the Controller General or an officer of the IBM authorized in writing that is a competent authority to take the mining. Nobody else. Rule 11. Mining operation under mining lease. No holder of a mining lease shall commence or carry out mining operation in any area except in accordance with the mining plan approved. Well, look at the way it's formulated. It's a prohibitory language, except in accordance with the plan approved by the IBM. Look at the importance and the status given to the body, which the central government itself is dismissing as a technical document. If the mining operations are not carried out in accordance with the approved or certified mining plan, or any information contained in the mining plan is found to be incorrect, misleading, or non-compliant with the applicable laws, including these rules, the competent authority may by order suspend all or any of the mining companies. Look at this power. You can stop the mining. It's like almost cancellation release of mining and permit continuous operation are required to restore the condition of the mine and the approved person. Every approved mining plan shall be subjected to review in every 5 years. And whereas in Rule 35, it addresses the issue of sustainable mining, which syncs with the overall object. Whereas these 4 pages are very important, 17 to 21. Or all the provisions, the lordships could come back kindly to my para B6. But above that, the lordships can know that all the provisions are quoted. It is interesting that while a very large number of functions and activities in the realm of mining are specifically delegated to state governments, there are significant exceptions where the central government alone is retained as with important ones. Approval of mining plan cannot be delegated to the. Why can't the lordships have a provision that mining plans can be approved by central government, IBM, and or state government? Why not? You have got 100 provisions there saying state government can do this, that, and the other. They don't delegate this. Because this is a very primary technical function. The IBM actually very difficult. People from foreign scholars come and seek information, study them. It's one of those old technical bodies, which is not part of the bureaucratic structure in the normal bureaucratic sense. One of the persona designata, the central government, the owner of the minerals, the entry 54 entity keeps it to itself. Doesn't give delegation to state governments. Both the concept of central government IBM approval and also the concept of mining plan exist in the statute and the rules from the inception in 1957. Because when your lordship gets 12A, what is the ultimate objective of Mr. AG's argument? Ultimate effect of his argument. 12A, MDPA trumps. It's a bad expression to use nowadays. Trumps versus mining plan. In one sentence, that's his argument. Whereas the statute in 1957 onwards uses section 528. This was the Johnny come lately, 12A, in 2020, 2021. It trumps the statutory provision in the rule. And look at the perspective, brothers. That's my D7. The heart of a mining plan, the whole next page, D8. The heart of a mining plan proposed by the lessor and approved after much analysis and scrutiny. This is the heart of the matter where the IBM scrutinizes it. Is the specification of production limits in a year. This is vital since it is intended to ensure a systematic, scientific, non-exploitative and phased sequence. Systematic, scientific, non-exploitative and phased sequence of extraction. Keeping the consideration of environment, ecology and safety in mind. It is conceptually not possible to sync compulsory notional dispatch with this mining plan. It is just not possible. You cannot do it because they are North Pole and South Pole in conception and design. And never the twain shall meet. It is tried that there can be no removal nor any compulsory dispatch without production. There is a patent mismatch between the mining plan, specified regime by the IBM, specifying production figures for different years, and the suddenly supposed compulsory dispatch regime of 12 years. The two cannot and in fact are never in sync. This is by itself a sufficient ground to strike down the interpretation and application of 12 years. I will, with your lordship's permission, jump to D11 now. And we are slowly coming to the end.
Yes, these are Some provisions quoted in D10.
This is the one, it's not solvents.
Yes, yes, yes,
So
yes.
they are just for convenience, you have to see from the statute. They are the very same, 528, CR, then the MCDR, all about mining plan, all about IBM, all about IBM. So therefore, the flavor is entirely statutory. Look at this one, D11. D11. I just made out an itemized hypothetical example and one letter out of 4. Yes. To take a specific example, in year 4, while the mining plan stipulates the figure of point, I'm sorry, this is an actual example I take
Yes.
in our case. So this is pleaded in the writ. This is pleaded in the writ. While the mining plan stipulates a figure of 0.6 MT in year 4 months, in my writ, the compulsory dispatch imposes 1.36. That is 3 times. Oh, sorry, 2 times. 2 times. The mining plan is 0.6 because the top technical expert of IBM agreed with me to scale down production on account of serious safety concerns. Look at the mother's complete dispatch. Either you say that I will decide safety, I will decide compulsory dispatch, I will decide everything. I'll amend the act. Now turn to only one, not to be double tick B, B for best. Only one out of many letters. This is the convenience volume of documents first. Not of the case law, but of documents. Page 22. Page 22. Do I lost have those? That's the compilation page.
Yes, yes.
22. I'll be proceeding with the
Wrongly written as a letter. It's a resolution of a meeting.
yeah,
in a
no,
meeting.
meeting.
So it's a resolution.
Officials, just note the date. This
4/3 is the date of
The
the meeting.
meeting. Now, whereas the people present also have seen, a lot of senior officials, etc. Now come to the first dot. First dot. Sukhinda chromite mines have over 52 lakh tons of chrome ore mineable reserves. There's a lot of the first dot. There is a dot.
Yes, I know. Bullet point.
Sorry.
In a bullet point,
Bullet
yes.
point.
Yes.
So the first dot is Sukhinda chromite mine 52 lakh tons of chrome ore mineable reserves through open cast mining methods as per approved mining plan by IBM in 2020. After meeting the targets of 13.6 lakh tons for 2 MDPA years, so that forget that. The remaining reserves through open cast mining by beginning of the 3rd year, that is from July 22 onwards, would be 24 odd lakhs. Considering the MDPA targets, and they are relying on the MDPA ones, the other side. Considering the MDPA target, 17 lakh tons per year from 3rd year onwards for Sukhinda open cast reserve would exhaust within 1.5 years from July. So this is a very scientific explanation. The depleting open cast reserve of chromite ore has necessitated initiation of the underground mining project as per approved mining plan by IBM. There is delay in starting the underground project by more than 1 year against approved mining plans, considering the pandemic, etc. Director of Mines advised TSL, that is the Tata Steel, to come with approved revised mining plans with timeline and production plan for underground mines in 2 months. So far, so good. Now, this letter asks me to give a plan. That plan is given and it is approved. After detailed discussion, I can take a lordship through them and not necessarily because we have to consider the factor ultimately. We are on common ground that mining plan stands approved. We are also on common ground that no mining plan is being violated. And we are also on common ground if it is violated, you have a 25% bank guarantee or you have some other penalty under section 20. These 3 things are on common ground. Now, the basic point I'm making in D11 is that mining plan which is approved pursuant to this meeting is 0.6. Mining plan says thou shalt produce 0.6. And no more. I'm sorry, and no more. Because of various considerations we've discussed, we've scrutinized, we've examined, we've inspected, blah, blah. And they say you shall export minimum 1.36. And the difference of 1.36 and 0.6, I shall penalize you. Apparently, that figure translates to a penalty of 2,000 crores for that alone. 0.6 minus 0.6 is 2,000 crores alone. Now D12 also. It may be stated herein that the modification of the mining plan of the petitioner was undertaken with the advice of the director of mines. I can't do it myself, but I can't say I'll produce 0 or 20. It's grossly below the Article 14 also, apart from everything else. Now come to D13, very important. If the MDP is given primacy over the mining plan, then all considerations of safety, geotechnical issues will have no bearing. In this position is accepted, it will not only result in mining lessee undertaking mining operations that are devoid of scientific, systematic, and safety consideration, but will also render the significant role of ICM as a technical result. Now, my learned friend does not purport or pretend or even claim to do any of this with scientific, systematic, or safety consideration. He is not claiming. But yet the effect will be on that. He is saying, no, you must do my compulsory dispatch. I don't care. All those consequences follow, they follow. I am not concerned. The person who is concerned says, no, do 0.36 because I am the safety control. This position is directly in conflict with the very statutory scheme of MMDR and rules. In the instant case that the petitioner's mining plan got revised to 0.6 as per procedure, the petitioner is bound to conduct operation as per revised mining plan. Then clause 10 of the MDPA. Now I am turning to something which I have shown must give way if irreconcilably conflicting with the mining plan. It must give way. But now let us look at that alone without prejudice in the alternative. Clause 10 I have put it at D15. The mining plan applicable to pursuant to clause 5(2)(b), or as the case may be 8(b). So all of the mining plan is traced to statute. Shall be complied with by the successful bidder at all times. The successful bidder shall also comply with applicable law. Whereas what is the problem? You are creating disharmony by telling the court that MDPA will prevail, that mining plan is just a technical document. Where is the disharmony? The harmony stares you in the face. Whereas this document on which you rely, Mr. Respondent, says that I shall comply at all times with the mining plan. So it maintains their primacy. It is therefore astonishing, to put it mildly, that the central government at part so of its counter affidavits purports to say, I am quoting this counter affidavit, which is quite astonishing. It is important to mention that a mining plan subjected to MDP, there is a typo there. What they mean is mining plan is subject to.
True.
And MMDR and the rules made therein. Any plan not in conformity with MDP and MMDR with rules cannot sustain. Part of the poor English words, it's also poor law. How is this law? Your mining plan cannot sustain because it violates the MDPA. You are saying this for yourself. This is even more surprising for the simple way central government acting through ethics regulator is the custodian of the mining plan through the IBM. This strange stand of the central government is variance with the elementary principles of law, wherein a contract will never trump a statutory document like the mining plan. And its common ground is the NDPA ultimately arises from the contract. The mining plan traces itself to a section 5(2)(b). Well, common sense law tells you who will trump whom. Now, this last E I can skip is a small and consequential point. I will just end with one thing. As I said, this is over on the constitutional legal challenges. But just not for Lordship to decide, because the Lordship.
No, I understand. You have already
Yes.
put a caveat on thereupon that you have many other points.
But just to spend less than a couple of minutes only to see my first note, the one which I opened with, which is in your Lordship's top of the file, and note the nature of the objections, which I listed. I'm not going to argue it. It's just 32, that book. Page 32 of that book. The Lordship has a flavor of it, that's all. There are substantive.
So incidentally and accidentally, you are taking us to the merit.
No, I'm not, because I'm not asking for a decision. Your Lordship has said your Lordship deciding this first, your Lordship decide that later. No problem. Your Lordship will decide it later. I'm just
Yes.
telling your Lordship that there are major credible grounds pending in the first note bills. I'll read just a few paras very quickly without any.
It's a breach of the principle of national justice, you have said.
No, 4.1. Let's come to 4.1 first. In that, first note, page 31, para 4.1.
That you have already said, that
This I already said.
when it was modified to 0.6 metric ton, how can you dispatch 1.36? There is a disparity.
Somebody may have a different, I may have a different figure. The next is 5.7. Again, I'm only giving you a flavor. I'm not asking you to decree on a decision on the merit, not that. That's not the object. A bare perusal include demand notice shows the dispatch target for the 5th year is taken as 1.3, which is the target applicable for the first 2 years. In other words, has been blindly extrapolated. The 8 continues, blind extrapolation replication to non-application of mind. This is a factual dispute. Instead of taking annual production, the authority erroneously taken the average annual production. Then what is 5.12? A perusal notes that the same demands are raised for the other 4 categories also, based on shortfall. Based on shortfall. And then what is 14 and 15? Even assuming 12A2 is constitutionally valid, the demand are without jurisdictions, without any power under 12A2 to make it.
That you have said, there is only 2 years
That
and not beyond.
Yes. And then, no. Now it's 5.19 and I end 5.19. Further, by virtue of the demand notice of 3.7, the state government seeks to extract from the petition number 1 the premium amount of 93.75 of the value of the alleged shortfall amount, even prior to the dispatch of the alleged. By such exaction, the state government seeks a double payment of premium amount. The first, namely the present demand, and the second, at the time of actual demand, actual dispatch of the said alleged shortfall, which will be paid. This amounts to double. These are some factual things you also may or may not see later, depending on the outcome. And I'm extremely grateful for very patiently.
Thank you. Are you not like else? Are you not feeling hot?
So that I'll try not to repeat anything of what Dr. Singhvi has said.
Yes.
And hopefully, my lord, assist your lordships in resolving, shall we say, one important part of the puzzle. My lord, the Attorney General, with respect, said that the expression mining operations is a compendious expression. It means excavation. It means winning a mineral. It means stacking a mineral. It also means removal of a mineral. Now, my lord, the question is, we are dealing with an obligation being imposed upon the lessee by a rule. Which rule obliges you not only to maintain a minimum level of action, but also obliges you. It says in the first place, my lord, the 12A in 2020 said, to ensure 80% of that quantity to be available for dispatch, which later became a lot of compulsory dispatch. And the Attorney General says that, well, dispatch is necessary because if this means something in public interest, then mining operations must actually reach the places where these minerals are intended to be used. And therefore, he says that flow into the market, that act of little compulsion by providing for a penal provision, is completely consistent with the MMDR. My lord, this is the point. Now, my lord, till now, your lordships may have been wondering that what is the Act actually having to say about this? The first is, my lord, this Act talks about empirical facts of production and empirical fact of removal. My lord, this is very important. This Act, for the purpose of payment of royalty or anything, my lord, or even on the examination of getting it weighed, operating it on the IM3 system, you need to physically remove the metal. So, my lord, physical production is an empirical sine qua non under this Act and the rules. The physical removal is also a sine qua non. Now, is a compulsory dispatch? Why is it that a compulsory dispatch looks like alien or extraneous to the Act? Well, that's the puzzle I want to deal with. Why is it that the Act does not compel a lessee to dispatch? And the answer, my lord, is to be found, in fact, in all these rules. One set, my lord, my distinguished friend referred to the mining plan. That's one species of it. But I'm going to deal, my lord, with the, which is market and price. And both these, my lord, are really covered by the regime of these rules under this Act. So in other words, my lord, I'm going to show to your lordships that the sale which takes place between a willing buyer and a willing seller is actually, my lord, the basis of removal and royalty. This is, my lord, extremely significant. So if I demonstrate, my lord, that the statutory basis of removal in arm's length transaction, which means, my lord, a free market between a free buyer and a free seller, then, my lord, it is clear that the suggestion that you could have penalty and you could actually compel every lessee to dispatch, my lord, 80% of that stock, which later becomes, my lord, total of what he is actually produced, as your lordships will see with the amended rules. My lord, what happens? I produce. Yes, I understand. It should be available. But, my lord, if there is no, then, my lord, where do I get what is called an arm's length sale? This is the first point. The second is, why is, my lord, an arm's length sale so important in free market? Because, my lord, based upon the sale price of this arm's length sale, my lord, the IBM publishes the average sale price. The auction, my lord, which has a reserve price under the auction rules, actually takes, my lord, the average sale price published by the IBM. So, my lord, the whole universe under this Act of all the rules, one part is the mining plan, which Dr. Singhvi has dealt with, but really, my lord, the more critical part for us in examining the issue of 12A, 12A, 1A, 1B, 1C, and so on and so forth, is this point, that is sale between a willing buyer and a willing seller, and is that the benchmark under these rules? Well, Lord, this is the benchmark. I'm going to show to your lordships the rules.
No, when you talk about an average sale which is fixed or determined by
Yes.
then the concept of a willing buyer and a willing seller that may not match with the average sale price which has already been fixed by NIU.
No, but what how it's done is
Difficulty is that this concept actually this is borrowed from that particular determination in a land acquisition cases
yes.
where the willing buyer and the willing seller.
Yeah, but
set
it
has some.
says so. I'll explain
If
that.
it is that, then
Yes.
sometimes it so happen
Yes.
that a person who is in need of a ore
Yeah.
more, who is having a, I would say, or deficit of a ore, may offer better, more price than the others.
Correct.
to have this.
So those are the dynamics of trucks.
So
Those are, your lordships are right. But
then the
what
royalty has to be calculated on what basis?
it has to be calculated on the actual sale price.
Yes.
It has
So
to
now,
be
what is the concept of this average sale price by the IBM?
well, that is, it takes all the actual sale price for a month. Well, that is all the actual sales, arm's length sales, they are averaged out. So, Malad, what is critical, I want to show to your lordships, is the concept of an arm's length sale. And Malad, once that is clear, your lordships will understand why is it that a compulsory dispatch which has an impact upon arm's length sale will have an impact on royalty. It also, Malad, is extraneous for the purpose of testing the virus of the provision. Malad, may I just hand over my written submission? I just want to deal with this aspect first, and then I'll go to a second aspect as one raised by the Advocate General. And yes, please.
This is simply I think the reply to.
Yes. It should be very clear, Malad. Please come to paragraph 26 straight away. Let me deal with this point first, Malad. And then, Malad, a few general comments on the
Yes.
penumbra, the mystery of penumbra. The object of sustained production of minerals is achieved by production. Dispatch, on the other hand, is driven by market forces, fallacy in the argument of the union. The object of sustained production of minerals in the country is achieved if the lessee is maintaining adequate level of production. It is only if the lessees are defaulting in achieving the production target under MTPA will there be a situation of shortage of mineral. However, as far as the subject of dispatch is concerned, the same is not under the control of the lessee, but the demand of the consumer or the downstream industry. The object of sustained production requires that there should be adequate production of minerals to meet the domestic demand, and not that there should be dispatch of mineral oblivious or impervious to the market demand. The object of the 2020 amendment is to ensure that there was no sudden shortage of production of minerals in the country, as many leases were coming to an end in 2020. The immediate concern behind introducing sections 4B and 8B in the year 2020 was to ensure that there is continuity of production. This concern was borne out of the fact if new lessees would need to apply for fresh statutory clearances before they can commence production, a halt or a delay in production would necessarily have been a consequence. Dispatch is not solely under a lessee's control. Dispatch on account of as a bona fide purchaser of mineral.
Your first part of this submissions have been reflected in a judgment which we delivered in the first pattern.
Oh, I see, my lord. I'll quickly request, yes, please do.
Today itself,
Very grateful.
item number 1.
Very good. My lord, I'm very grateful.
It has not been uploaded.
My lord, then please see paragraph 29. My lord, I'll quickly deal with it. I'm very grateful.
Today only it was.
Yes,
so it is not uploaded.
My lord, now I know, my lord, about ILR and the publications. One doesn't, my lord, always get an opportunity, but I know, my lord, that this High Court has maintained its portal with great, it's one of the most, my lord, advanced, digitally maintained, shall I say, portals. And the definition of the word dispatch was inserted by way of an amendment on 28 March 2020.
Oh, it's uploaded only. Yes.
My lord, your lordships have overtaken these young men. It's clear. In alacrity, my lord, but then that is, my lord, that is, I think, the report. On 28 March 2021, added by Amendment Act 16 of 2021. As per the said definition, dispatch means removal of minerals or mineral products from the leased area and also includes the consumption of minerals and mineral products within such leased area. My lord, I want to make a small comment here. Section 9 of the 1957 Act is still in its unamended form, and it uses these words remove or consume. So, my lord, the word removal or consume are a part of the pristine, the Act as it was enacted. That is why your lordship finds this now in the definition. The removal of mineral is occasioned by an event of sale or captive consumption. That while the lessee can be the seller, there will have to be a bona fide purchaser for the event of sale to take place, which will result in dispatch of mineral. Under Chapter 12 of the MCR 2016, which concerns itself with mineral valuation, Rule 38 provides that sale value is amount payable by the purchaser as indicated in the sale invoice, where the sale transaction is on an arm's length basis and the price is the sole consideration for the sale, excluding taxes, if any. Now, my lord, this rule uses the word arm's length basis. And that, my lord, if I may say so, clearly tells us it's the sale price, as your lordship said. It's the invoice price driven by the dynamics of the market. And that is, my lord, the basis for calculation of royalty. Further, Rule 42, which provides for computation of average sale price on the basis revenue of the state is determined, provides under Subrule 2, Clause C, that where sale has occurred between related parties and or where the sale is not on arm's length basis, then such sale shall not be recognized as a sale for the purpose of this rule. It is submitted that if arm's length are to take place on the basis of market forces, there cannot be an obligation to dispatch unmindful of the above principle. The submission of the union has been completely unmindful of the statutory scheme, the average sale price being published by the IBM on this basis. Further, that the IBM itself recognized that there was no shortfall in terms of meeting market demand. The union has not answered either in terms of law and practice that sale and removal are only controlled by market demand. And additionally, the union has not pleaded on affidavit adequate facts in relation to scarcity, shortfall. No, the union has not filed any counter in opposition to this petition. In fact, my lord, the learned Attorney General referred to the 2025 amendment. My lord, that has come into force on the 1st of September 2025. If your lordships even look at that amendment, it talks about a free market to be facilitated, my lord, with an exchange. So, my lord, the purpose of a market, free market, my lord, in the electronic exchange, which they are going to now install, is to enable traders and sellers to come together. So, my lord, it is really to freely determine. Therefore, my lord, there cannot be a compulsion to actually flood the market without there being a market. It is submitted that sale which is recognized under the statutory rules, especially for calculating the average sale price, for eventually determining the revenue of the state, is a free sale driven by organic demand in the market. The said sale should be at arm's length and not with a related party. Thus, dispatch must be on account of sale done by bona fide purchasers in the market and not a forced or orchestrated or sham transaction of sale for the sake of dispatching. Another drawback of forced dispatches is dumping of mineral in the market without commensurate demand at throwaway prices. This will ultimately lead to loss for the state, as throwaway sale prices will only lead to lower ad valorem statutory payments as royalty or bid premium, etc. The production as well as dispatches in the month are required to be reported by the lessee under Rule 45 of the MCDR by way of monthly returns in Form F1, whereunder a lessee, while reporting dispatches, is required to give details of purchasers and consignees along with the sale value. It is quite clear from the scheme under the MMDRI and the rules that there must be a bona fide purchaser to whom sale is made resulting in dispatch. There is no scope of a ghost purchaser or a sham transaction of sale. It is thus admitted that dispatch cannot be an obligation saddled upon a lessee, as the event of sale requires at least two parties, the lessee and a bona fide willing purchaser. Now, my lord, this argument about hoarding and stockpiling, actually, my lord, there is no evidence. In fact, your lordship has seen the IBM letter, which Dr. Singhvi referred to, which says that actually the demand has been squarely met. Now, my lord, I only wanted to read that 2025 amendment because it shows to your lordships what is the recognition by Parliament of. Please have a look at, my lord, the new book. Yes, my lord, that's the commercials new book. In the very opening, your lordships will find the 2025 Amendment Act, which has come into force on the 1st of September 2025. This act, my lord, is significant because this tells us exactly what is the position and what does the government intend to do. Please see, my lord, 2AF, there is a new definition called mineral exchange. Mineral means an electronic trading platform or a marketplace registered in accordance with the provisions of the Act, where buyers and sellers of minerals, its concentrate, or its processed forms, including metals, transact, trade, and enter into contract, including in derivatives. So, my lord, it's only clear this is going to be a facilitator of market. So, my lord, if that is the intention, now let us look at, my lord, please come to section 9, 18B, development of market. Development of market. The central government shall endeavor to promote development of market, including trading of minerals, its concentrate or its process forms, including metals, through mineral exchanges in such manner as may be prescribed by the government. Now, my lord, your lordships will notice this is really to increase trade. It is to improve markets, which means, my lord, a willing buyer and a willing seller are going to be facilitated. So, my lord, if this is the intention of Parliament as on the 1st of September 2025, my lord, these three rules cannot simply act as interlopers and completely contravene, shall I say, or militate against the spirit, my lord, of a sale or removal of coal. Yes. Yes, my lord, may I also, I'm grateful to my friend. My lord, we also have, if your lordship sees that policy initiative, the document of the government of India for this amendment, your lordships will see the, I'm sorry. Please see Roman 4, my lord. The central government has been empowered to promote development of market, including trading of minerals, its concentrate or its process forms through mineral. Setting up of mineral exchanges will help miners and end users in determining fair and transparent market prices based on supply and demand dynamics, stabilized markets, and aid in budgeting and planning. The limit of sale of minerals from captive mines has been removed. The miners can now sell minerals after meeting the requirement of the end-use plant linked with the mine and on payment of additional amount specified in the Act. So, my lord, if your lordship sees, the entire thrust is towards.
No. This is what he says that the Attorney General has already referred that particular amendment, which has been brought into edition. He's saying the object and the idea behind that particular amendment to be brought. He has brought it from the public domain document.
It was not documented by learned senior.
Yes, certain.
You just complete.
Yes.
You make a-
Yes, certainly, no, please.
No, he's completed.
I just wanted to read the relevant portion, my lord. Then, my lord, I now want to quickly deal with, my lord, there was a submission made by the learned Advocate General. Let me deal with it very quickly, my lord. He said that there is a notice of 8 September 2021. You have come up with a writ petition in 2025. My lord, the answer is very simple. But what happened was, one of the conditions at the time when we bid was that we could actually send the mineral excavated for processing to a subsidiary company. Now, my lord, the subsidiary company, we had a subsidiary company. That company is called Amalgam. And, my lord,
Yes.
and what happened was that, my lord, they were not dealing with our applications to register that company. So we came, my lord, to your lordships. Your lordships passed actually a protective order in 2021. And then, my lord, despite there being a protective order, they issued this notice of September 2021, but they did not act upon it because it was clear that it was in breach of the order. Finally, my lord, we also were dealing with the question of relaxation of demand because the ultimate permission which they gave was after, my lord, my first lease year was over. My first lease year, my lord, began on the 29th of June 2020 and, my lord, ended on 28 June 2021. And I have been pleading with them to give permission, and, my lord, they gave me permission on a day, 3rd September, in September 2021. So, my lord, really the first year, which is really, I'm a captive mine. Being a captive mine, as your lordship will see in the first part of this note, your lordships will notice what they have done is they imposed a demand on me, my lord, under Rule 12, capital A1. Please just see that with me. It's really a case which really strikes us in the face of it. Please just see this for a moment. Please see 12A. Your lordships will see Rule 12A1.
Page 572. Page 572.
12A1. Notwithstanding anything contained in these rules, during the first 2 years, I'm sorry.
Yes.
Notwithstanding anything contained in these rules, during the first 2 years, from the date of execution of new lease, the holder of mining lease to whom the order of vesting of rights, approvals, clearances, and license have been issued shall maintain such level of production so as to ensure minimum dispatch of 80% of the average of the annual production of preceding years on pro rata basis, failing which appropriate actions in accordance with the MDPA shall be initiated. So, my lord, they purported to act under 12A1. And actually, my lord, my production was more than 80%. They didn't give permission for processing to the subsidiary, and they acted under 12A1. But, my lord, if they had acted in terms of 12A1, which is to take action under the MDPA, it was nil. The figure is 0 because, my lord, there is no shortfall in production. Your lord, Schedule D. It is only on shortfall of production and actual production. There is, my lord, something which is charged. When there is no shortfall in production, it is 0. So what do, my lord? They then take the measure of penalty under this 12A1A. Your lordship sees 12A. So, my lord, they've charged us all the amounts under 12A1A. But, my lord, they forgot that 1C. 1C says, for the first lease year, these rules don't apply. And, my lord, the first lease year is the only year with which we are concerned in my case. So I'm just showing to your lordship, with reference to these rules, if your lordship says, takes just the first part of my note, it's just, my lord, a few paras I have to show you, nothing further. Please see para 4, my lord, of my note. Rule 12A1 for the first time, that is on 20th March 2020, spoke about minimum production to be able to ensure 80% dispatch. The emphasis was on production, and dispatch was in the context of an arm's length sale based on market conditions. The theme of the rule was production, and dispatch was incidental. The first time an obligatory minimum level of dispatch was introduced by the insertion of Subrule 1A in 12A with effect from 1/7/2021, along with insertion of 1C, which categorically states that Rule 1A, including any penal consequences, will not be made applicable in the first year. Further, the impugned demands 8/9/21 and 15/1/25 were appropriately raised under Rule 12A1, since the writ petitioner had maintained requisite production of 80%, Rule 12A1 could not have been invoked at all. Para 6 at page 20, writ petition, well, the requirement is 22.76 lakhs. Actual production is 24.82 lakhs. This is not deniable. The state chose to issue a demand notice with reference to the penalty under 12A1A, which clearly was prohibited by 12A1C. The first lease year commenced from 29 June 20 and lasted till 28/6/21. The third amendment rules became effective on 1/7/2021. Hence, in terms of 12A1C, no demand could have been raised under 12A1A. Net result is that both notices are liable to be quashed. Well, this is a simply ex facie case. There is no question of any facts. This is a case where someone is applying a rule which he is prohibited from applying for the first lease year. Now, this is really something which is stark. In this case, it is so stark that on the face of it, the first year, your production is fine. Second is you delayed giving him the permission for a subsidiary. But in any case, you realize that if you go by the MDPA, the penalty will be 0. So you apply a rule under 12A1A, which you can't apply because it is only after the first lease year. Well, this is a straightforward case, absolutely straightforward case. There is no contest at all as far as these facts are concerned.
When lease deed was executed.
My lease deed, Manoj, was executed on, that is 29/6/2020. So, Manoj, the first lease year is 29/6/20 to 28/6/21. And, Manoj, they have slapped me for shortage in dispatch only for this first year. There's no shortage in any subsequent year. Only for this year, they say you should have dispatched also. But I said I have produced 80%. Dispatch also I could not have done because you sat on my application making a subsidiary. Well, this is just an open case. And they apply 1A. Well, of this.
But the 80% is relatable to a dispatch, not relatable to a production. It says that previous or a preceding 2 years or a previous 2 years, the annual average or the average production which was done by the erstwhile lessee, that you have to maintain and ensure that particular level for a first 2 years, and dispatch of a 80% is incommensurate with that.
Well, that dispatch, as I said, if your lordship accepts my submission, is that 12A, it was really incidental to production. That is available for dispatch. Then, Manoj, it's available for dispatch. Then I satisfy the rule. But the consequence, Manoj, for failure to dispatch came only by virtue of 1/7/21. Therefore, Manoj, that cannot be, because they've said first year is simply excluded. Now, Manoj, let me deal with, I have not developed this point in the other paras. I don't want to take up more of your lordship's time. This, Manoj, is one simple, straightforward point. Now, I may also read, Manoj, 12A1C. Your lordships have read it. But
Yes,
12A1C.
I have read it.
Well, in para 13, I've set it out. Your lordships have read it, Manoj. So, my lord, I have summed it up in para 14. To summarize, no demand could have been raised for a shortfall in dispatch in the present case, primarily for two reasons. Firstly, the consequence in shortfall in dispatch were introduced by way of Sub-Rule 1A with effect from 1/7/21. The impugned demand notices were raised for the first year from 29 to 28 June 21. In fact, the demand notice was issued on 8/9/21, even after the operation of the Third Amendment rules. In the light of the express prohibition in 12A1C, the demand is without jurisdiction. Secondly, the state in the garb of the impugned demand under Sub-Rule 1 of 12A has in effect sought to impose a demand under Sub-Rule 1A for the first lease year, which has been prohibited. So, my lord, it's a simple, straightforward case. And now, my lord, if I may just say, my lord, if you go by that MDPA agreement, it all, my lord, comes to nil. That also we have set up. Now, my lord, let me deal with another point. And that is, my lord, an important one. So your lordships now have heard, my lord, on the question of this. One moment, please. Your lordships have heard, my lord, on the question of the mining plan. My lord, it is clear that arm's length sale price is the basis. And that is why your lordships were wondering that what is the regime which actually leads to removal. So physical removal, my lord, happens pursuant to a contract of sale. That is why, my lord, in all the forms, including the IC3 system, my lord, everything, including the name of the consignee, the sale price, my lord, the weighment, everything is done electronically under the IC3 system. So, my lord, today it is clear that there cannot be what a putative removal, what my learned friend Dr. Sigvi referred to as fictional. There cannot be, my lord, a putative removal, something to be assumed to be a removal, when in fact, my lord, there is no de facto removal. So, my lord, the law contemplates under this act de facto production, actual production, de facto removal. It is only then, my lord, then there is a de jure obligation to pay for the purpose of royalty and also comply with all other provisions of the act. Then, my lord, just please give a compilation. Oh, well. My lord, I have also dealt with in paragraphs 19 and 20. I have dealt with the head of the demand notice and indicated that, my lord, the charging provision which they have quoted is that 12A1A, which they could not have, because that, my lord, doesn't apply. My lord, just give it a part. Now, my lord, I come to the subsidiary point, sir. My lord, on the point about subsidiary, I have made it clear, my lord, that there was a delay. It was by virtue of your lordship's orders giving the direction that they must take a decision within 2 weeks. Ultimately, my lord, in September 2020, they actually gave us permission to transport it to the subsidiary. Now, that's not confusing. Now, let me deal, my lord, with this point relating to penalty. My lord, I'll sum it up again. There's a big anthology of, shall I say, case law, articles, and so on and so forth. But let me sum it up. I have dealt with it also in my submission. Well, the point is that penumbra had two phases. This doctrine, my lord, is a doctrine peculiar to the United States.
Mostly applied in interpreting the constitutional provisions.
Right, my lord.
In all the cases which have been
That's
delivered, mostly they applied the principles in that way.
In that way.
So far as this extension to a statutory provision
Yes, it
for
is not
interpretation
It is not done.
is still at the very nebulous stage, I must say, so far as the Indian jurisprudence or the Indian legal system is concerned.
And I'll indicate why, my lord. You absolutely, extremely well. My lord, prior to Griswold's case, the judges who used this expression of penumbra meant something which is uncertain or dark or gray. Suppose, my lord, limitation is expiring tomorrow. A man is filing it at 6 o'clock in the evening, but it is past the office hours. What do? Do we treat it as barred by limitation? Well, it's these kinds of things which they said comes within the gray zone of uncertainty, uncertainty about what to do. That was how doctrine began. My Lord Justice Douglas, William Douglas, used this in Griswold's case for the first time in the context of a right to privacy. My Lord, how did he find out this right to privacy in a penumbra? He said the right to free speech under the American Constitution, my Lord, is a guaranteed First Amendment. And he said that if one looks at that right, there are some facets of that right which they have not become fully manifest. They are hovering on the fringe, my Lord, of that right of free speech. And that fringe could include the right of privacy. My Lord, it is this passage which Justice Matthew, my Lord, took note of in the celebrated judgment, which has now been affirmed, my Lord, as far as the right to privacy is concerned. It was in that context. But, my Lord, scholars have analyzed and said this penumbra is not a substantive doctrine. It does not lead to incorporation of any new jurisprudence. And in fact, my Lord, scholars have found that, my Lord, it has now fallen off even in the United States. Even in the United States, penumbra today is not, my Lord, a favored approach because of the need for positive law, my Lord, because penumbra by the very nature looks like as if there's an eclipse and you're looking at something which is on the edge of an eclipse. My Lord, in India, we use this expression, my Lord, in the sense of fundamental rights, as your lordships right. Why? Because, my Lord, our law, after Maneka Gandhi and the other judgments show that all fundamental rights, my Lord, are interrelated rights. My Lord, when fundamental rights are interrelated and intersect with each other, you don't know exactly which is the common portion which is intersected in which right. Which is why, my Lord, the Honorable Chief Justice Chandrachud has said that in our jurisprudence we use penumbra really because of the fact that fundamental rights 14, 19, 21, my Lord, all of them coalesce and literally merge with each other. So, my Lord, this really is the basis of the doctrine as far as penumbra is concerned. I have made the point. My Lord, I wanted to, my learned friends want me to show one table, my Lord, which is in para 20 of my submission. My Lord, para 20 is, I have pointed out on the left-hand side, my Lord, in the chart, head of demand in the impugned notice. So, my Lord, although it is claimed under Rule 12A1, but the amount is claimed with reference to 12A1. Each one of these. So, differential royalty, differential DMF, differential NMET, value of performance security. My Lord, these are all available under that 1A, but not under 12A1. And then, my Lord, in para 21, your Lordship sees, if you go by the MDPA, that is the agreement, then minimum production requirement, actual production shortage is nil. And then, my Lord, there is the illustrative demand under Rule 12A, read with a in case of the petitioner. Again, my Lord, it comes to. My Lord, since I was given to understand that your Lordships were keen that we should try and condense our submissions so that your Lordships complete the rejoinder, I have, my Lord, compressed my submission. My Lord, I have also given an initial note of submissions with a list of dates. I have, 1 second, please. Just give a compilation. But I have a compilation with reference to penumbra. I have made and these articles, and my Lord, they are researched, so that your Lordship knows that what I said about the position in the United States is established, my Lord, by the academic work with reference to penumbra. I have, my Lord, set out, and I have also referred to Chief Justice Chandrachud's judgment. And, my Lord, I have also mentioned in para 24 that I am, my Lord, a captive mind, and the subsidiary was in fact permitted. Your Lordships will find that at page 9, para 24 of the submission. witness is a captive mine, expressly, categorically represented by the state, that a captive mine can also supply iron ore to its own plant or to a plant owned by a subsidiary. During the first lease year, where petitioner sought permission to
So
supply.
that was granted 1 year after
1 year after
the
that.
commencement of.
That's right, Manoj.
That is what your case is.
Yes, no. That's it.
No, that's true.
Well, I also have an extra pursuant to which, my lord, it was your lordships passed an order, and thereafter only, my lord, they gave us the permission to include a subsidiary. Don't go.
Is it not remotely, or I would say to some extent embraces the concept of a legal fiction?
Yeah, and your lordship's pardon. I'm sorry.
This concept of penumbra,
Yes.
does it not remotely touches upon that particular the principles of the doctrines of the legal fictions?
Of the legal
Fictions.
legal fictions. Well, what? It's a very philosophical question. The reason being, my lord, fiction is also meant to reflect an underlying reality.
Correct. That is what.
I understood. I understood.
That is why I was just
your
thinking
lordship
in
is
that
right.
line.
So it is like the illusion of a certain definite reality,
Which is not illuminated.
which is not illusion, which is, my lord, which is still candescent.
They're highlighting on 3 areas.
So something which has to be understood within that framework does not appear to.
What it is emanating from your
Yes,
written note that it is gray area which you are
that's right.
flashing.
And my lord, the point is, we speak about gray when something is gray. But if, my lord, there is nothing gray. If everything is clear to us, in statutory interpretation, my lord, if the legislature is clear, then, my lord, we don't add grayness to it. And it is, my lord, never the intention of courts to attribute to Parliament that Parliament did not know how to use words.
Now this when is caused can't be extended to cautious omissions.
To
Cautious omissions.
to cautious omission, my lord, cautious omission is founded on a principle of on a principle of, my lord, interpretation.
Different concept which is ignored or not foreseen.
Which, my lord, is necessary for the purpose, that omission is necessary to be supplied. The omission has to be rectified.
Something consciously.
Consciously avoided.
So, my lord, there is a conscious, shall I say, that is why, my lord, this doctrine of penumbra is really rights, and shall we say, the added scope of rights, or evolving nature of rights. My lord, rights is always a subjective phenomenon, right from the time of Hobbes and Aristotle. So that is why, my lord, it's used. But interpretation, my lord, is an exacting science. Interpretation of statutes, and my lord, I'm reminded of Crawford. The best book on interpretation, my lord, is the old Crawford, which, my lord, has that fundamental principle that words, where words are clear, unambiguous, the literal interpretation is the safest interpretation because plain and natural meaning can be accorded to them. Your lordships used that phrase this morning. Second, my lord, when you have definitions, the purpose of definitions is actually to avoid any form of circumlocution. The purpose of definition is not to allow any grayness to hover. That's the very purpose of a definition. And the definition, my lord, it has a functionality in a statute, namely that runs through
Says that,
like a
that
golden
the
thread. my lord.
uncertainty should not
Yeah,
omnipotent
That's right.
around
That's
everything.
right. That's right.
But even those Crawfords, at least I think the more we should not travel more seven seas away, should restrict here.
I agree. my lord.
Even our Vedic scholars have introduced this Mimamsa Sutra, which gives how to interpret the provisions.
Although there is that system of Nyaya,
Yeah.
that is, my lord, again, a very detailed system, which has got, my lord, agnate and cognate interpretation.
Which also propagates the first attempt is the literal interpretations.
Yes, ma'am.
And then if you fail, then take a purposive or a other way of interpretations
That's
in
right.
the nature of a context and the object and the
Object.
purpose.
Well, that's why Vyakarana is so important if you want to really study any of these texts. Well, if your lordships have any questions, I'm more than happy to. I'm
Thank-
grateful, my lord.
Thank-
Extremely grateful.
Thank you. How much time will you take?
About an hour.
The difficulty is that my brother has to travel to attend some programs organized by the NGA, National Judicial Academy.
So I can come again.
So if you can finish it within 20 minutes, welcome.
20 minutes won't be possible, Manoj.
Mr. Subramaniam was very, very, very miser,
Yes.
and he completed his argument in a nutshell manner.
He is more felicit smaller than. Will take some time. I can come again.
Because it's only you who are left, otherwise there is no argument to be advanced.
Yes, that's right.
Because you are in reply.
Correct.
And he requested.
Nothing, reply to a reply. I think Dr. Singhvi has concentrated only on the argument advanced by the learned AG and
No, madam.
Attorney General and the learned
Certain
advocate.
diversity is there. We'll reply to same 10-15 minutes. And
That
this
is
is
what is the reply. I think nothing new has been cited by them or something new. They were,
that's why I requested Monday.
Subramaniam also have really restricted.
But I am not.
He mainly focused on penumbra theory.
Yes.
Yes, so that was an argument of an attorney general.
Yes, yes. So what I'm trying,
So,
madam, Monday,
what
if
more?
the senior will conclude the argument, after lunch, the AG will conclude within 10-15 minutes, it will be ended.
There is no concept of a reply to a reply. Again, if you give something new,
Yes, addition to that,
there's
is
no
submitted something.
concept. If they argue something new, definitely I know you must have the opportunity to deal with that.
Only 50
These are-
time is required for submitting this. Attorney General requested me personally the last day.
No, we could have continued till 5. My brother has to.
I know Lordship is sitting. They are not like I know. So what I am praying, if he Monday, if he complete, then after lunch, Monday after lunch, on second he will take 15 minutes to complete also.
What?
Submission all these things. Let them complete tomorrow.
My lord, Raman is not here.
Or Monday after.
No. My brother will be there on Monday. There is no issue. It's only on a weekend
And first hour of my lunch senior may complete. After lunch, you.
because he has to leave for NGA program.
Saturday.
That's tomorrow and day after tomorrow, 2 days.
Available on Saturday.
No.
I'll be back on Sunday only.
Then you'll have to go to some other place to argue.
It's not working.
Whatever date can be.
Then either go to Bhopal or go to some other.